Hey, you guys. Good morning. You guys are here so early. So, hey to everyone. I was saying hey in the chat. I figured to start off, I don't know if we're going to get into the court feed. It's just showing the logo right now. But yesterday, Dublin Mug, who you guys may see in the chat, sent over the Little Rod body cam from over a year ago. So we had been doing a lot of conversations about, deputies possibly turning their body cam on and off. And while we wait, we're going to watch this. I'm going to refresh it because it's doing that circling thing. And no new motions. No motions yet, you guys. Which is crazy, but I'm sure some are coming.
Counselor's gonna have a seat. I'm gonna have a seat. Take the chair over there.
He can stay over there.
Yeah, he was getting out of my way.
Just stay over there. Straight.
Go ahead. You got something?
I'm gonna ask you this one time, okay? You smell like raw marijuana. When you walk back into the courtroom before, multiple people notice that you smell like raw marijuana. You're gonna be strip searched. Do you have any on your person? You just want to go ahead and hand over right now?
Yes, sir.
I can still smell it right here, right now. So I'm just asking. That's fine. I understand that. I'm having a conversation with you before we go forward. So I need you to go ahead and take your clothes off, buddy.
I'm saying, I ain't almost
Ron, take your clothes off, buddy.
Where the hell y'all got me?
Right. I'm just giving the instructions.
Let's reach out.
Okay?
Go ahead and take your shoes off.
Hold on one second.
This is body cam from last year of Lil Rod being searched in court. Just because we've been talking about, do they put their body cams on?
Where'd you get this from?
I've been at it on y'all day. You tried to give me my shirt, they got your shirt today.
So you got a shirt today that smells like weed?
Yeah, I had to.
Go ahead and take the shirt off.
Yeah, bud. I have no idea. I was told to come. Who told y'all to come?
Lieutenant Gibson just
Lieutenant Gibson did.
No, hold on.
They just went and talked to the judge right now. He said you're taking no recess.
What happened?
She's on her way up here to talk. Your sources.
You can check it again. And some shoes. Shoes.
Hold on, hold on.
Okay, every time I try to check law and crime and see if it started, it like slows this video down.
I can smell it hard.
Do they show that? There's no way they can show that. But they clearly show, like, they have cameras on. And they're using it for all... I mean, this is procedural, right? They should be documenting this. If they didn't document this, I think they would be in trouble. And they had turned it on right in the courtroom still. But not for all that long. Really just to get him into the custody. And we don't need to watch the search. I don't think they're going to show anything anyway, but you guys in the chat are like, oh! And I'm going to double check. Are we live yet? No, are we late today? Guys, is Whitaker late? Is Whitaker late? That's new. I bet the comments are calling it out over here. Law and crime comments. The chat on Law and Crime is crazy sometimes. Yeah, see, she's late. They're all calling it out. Okay, they're officially starting at 9. They're usually showing the top of her head by now, though. And thanks, Ecapone. Good to see you. I'd put justice scales in the chat, but StreamYard doesn't have a little emoji button. I can Google it. And I think we're going to see a new filing from Doug Weinstein. He still has an outstanding motion. It hasn't been decided on for the mistrial, but I think we might see a supplement. It seems like he was working last night, so this is my guess. I don't know some of the other attorneys. I'm surprised Brian Steele hasn't filed a renewed motion for a mistrial. But maybe we'll get that today too. I feel like right now at 8:30, the court clerk, anyone that did motions yesterday, filings yesterday, is probably like got this pile of papers that they got to get through. And there we go. I'm going to get the scale of justice emoji. I had to go to Google. There we go. E. Capone, Justice Junkie. Let me get rid of this banner, otherwise I will leave it there. We'll be watching the trial today and it'll still have the old banner running. Like, that's not what we're watching. So this was Lil Rod, and this was a year ago, and the reasoning was that they apparently smelled weed on him. But, that was just tying back to a conversation that, the deputies do have body cams. They might not always be running, but it looks like they turn them on as soon as they have to take some action. So yesterday we had heard that somebody, Deputy Brown, said, turn off your body cam during this June 10th meeting right before it started. So, just getting a little bit of insight in there. And AL, this is a great point that, this law and crime crowd, mainstream media viewers, they could be the jurors. If you ever have a trial, people just like in this chat could be seated for your jury. And yeah, he looked really young. I don't know his age, but he looked young in that footage. Blue's house, so good to see you. Are you talking about this trial at all? Guys, Blue's house is like the only reason I know anything that's going on in the comics or movie world. But he covers news sometimes too. Here we go. Let me get Blue's channel. There we go. This is Blue. Dang, Blue, you're almost up to 9,000 subscribers. That's awesome. And what's going on, everybody? Yeah, and I don't think anybody's looking for a plea deal. Put a 1 in the chat if you think someone is looking for a plea. Put a 2 if you're like, nope. And if you have something in between, just describe it. But a plea at this point, to me, it's just kind of like, I don't know, human psychology. You don't want to go back to the drawing board. I feel like I'd want to keep going. Especially, I do think the state's case is a little rough. I don't think it's the strongest case. So it would be in my favor to keep it going if I think I have a good chance of someone on the jury being like, I don't know. If this case is proven beyond a reasonable doubt, I just don't know. Yeah, and you guys, and maybe if you're someone with like, where you'd have a good plea deal on the table. I don't know what a good plea deal is though, because probation can be risky anywhere, but do you guys think probation is a safe bet or a gamble in Fulton County? If you're on their radar, I feel like probation would be a trap for any of these defendants. I believe, didn't Young Thug's brother take like a 10-year probation as part of a plea, and he already got caught back up in it? Yeah, like probation, I think probation can be a gamble anywhere. Some probation officers, they really don't let you come home late from work, and it's an arm and leg to convince them that you were really at work and you're home on time, or you're not home on time because you got out late. And they don't want to like hear you out that it's not your fault. It can be a trap. Yeah, it's just, and then in Fulton County, come on. And Judge Glanville says, sorry, I'm late. That's okay. Kat, Love was in my chambers trying to get her mic level correct so I can coach her through today's hearing. Judge Glanville, I love having you in the chat. Yeah, and this is crazy. So Mahadi De Jesus, they offer 15 years of probation. Like, think about that. Not messing up for 15 years. That might sound easy, but messing up is somebody else's definition, not your own. Like, crazy, crazy. And that's true on the other end. Fulton County spent their whole budget on this trial rather than fixing their jail, so why would they want to offer pleas? You know, maybe just to get that quick conviction, but I feel like from a media perspective, it would kind of look like a loss if they offered a plea. All right, we have a countdown finally. If they offer a plea and it's taken and they're publicizing, hey, this person 105 days into the trial just pled out. I feel like that would signal to people, the public that aren't paying attention, that why would the state suddenly be offering plea deals? It will just bring more attention on the state for possibly flopping this case. I think it would just be bad from a PR perspective. And yeah, you never know, your probation officer could be on a power high. And probation's expensive. So I might need some education there. I'm not doubting it. But what makes it expensive? Is it because you have to go physically and check in? Do you have to pay certain things? Educate me, chat, because that's a little bit beyond my, like, anecdotal knowledge. And Sweetie88, probation is just set up for people to fail. There just isn't enough probation officers that truly care about trying to help people. I think so, too. I mean, I don't know. I feel like, obviously, I'm thinking of movies and TV, but I feel like movies and TV might sort of get the caricature of a probation officer pretty right. Like, there's those ones that just want to catch someone tripping rather than just, hey, are you following the rules? Are you doing what you're supposed to do? I think there are probation officers that purposely seek to look for, like, the find the crime type of mentality. Dang, that's crazy. So you got to pay for all the stuff that they have you do. Dang. That's crazy. So imagine you get out, you have to find a new job because you were incarcerated. Probation officer wants you to get a job, but your schedule's all crazy. The job that wants to hire you wants to give you, like, the worst rotating schedule in the world, and they won't give you your schedule in advance, so you can't tell your PO. And then your PO's power tripping, so they make it a big deal if you have a rotate. Like, it's just all that. It's just, like, constant stress. Just a mess. Like, how does that help anybody? Good morning, Candace. Good to see you. And hold on now. I saw the lead in here say that probation was a trap, and that's the lead attorney saying it. He would know better than me because he's the lead attorney. I don't even see where his comment went. There we go. Good to see you, bright and early, lead. And yeah, so Asiatic adds, this is a great point. So there can be issues with felon status about trying to get jobs, trying to get an apartment. In some states, I think Michigan was one of them. So I did a lot of research on Michigan and reintegration, the success rate of reintegration, which is not very high in Michigan. And if you have felon status and you get out and you try to go live with someone who might be on government assistance, sometimes even assistance for, like, public student loans, that person you're going to live with, because you have the felon status, if you need an address and you need to make your address this your family members that you're going to live with, it could knock them out of their benefits that are in their name only, just because you're residing at the same address. And maybe there's been some progressive reform on that, since this would have been like 2012 that I was doing this research because I was still in school. But it was like, how do you get out? You can't go live with your family unless you want to put them at risk of losing the assistance that they need, sometimes even the assistance that they need to finish college. Where do you go live? How do you get back on your feet? How does that help prevent... They're on? Okay, hold on. Let's try another stream. Let's try 11 Alive, or let's see if Sylvia's there. I don't see it. Doo-doo-doo. Yeah, 11 Alive doesn't have it either. So still waiting. But it's just crazy. Like, the too long, didn't read. My summary of that was, like, when I learned that the other person could lose their stuff, it was crazy.
Ford is being proffered to support the position that alleged violations of the rules of professional responsibility are sufficient to support disqualification. For a couple of reasons, Your Honor, I just ask that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. That interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify, and if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shart's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shart's for a fair trial, set forth additional bases and suggest
That you didn't argue against.
that as one of the potential
Where's the critical stage argument?
remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shart's amended motion for a fair trial. So
Filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to
So still no written
get something
response.
to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
So jury's gonna come back Monday, you guys. Watch. Thank you so
All
much.
right.
What's that behavior? This is a perfect comment. Watching the insanity from the UK,
And so I
the
assume you have
corruption.
made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right. Yeah.
One more thing, we did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He sent it generally. It may
Oh,
have specific-
oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers, and
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so,
if that's the case, we would ask to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, it's evidence. But if the court proffers are okay, I'm okay with that.
okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls.
Yes, Your Honor. So I went back and reviewed what all we covered. So that
Okay.
we got through the 5 jail calls the state intends to introduce Mr. Copeland. And I also confirmed and spoke with Mr. Sharp, Mr. Steele. We were in agreement that we handled those jail calls related to Mr. Copeland on Friday.
Okay, I'm sorry. I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection.
In relation to the
Jail calls.
jail calls, yes, Your Honor.
Okay. So, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on, and there was other parts where, like, for example, one of them was Detective Gaither. He asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hylton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hylton. That
Okay.
encapsulates what all we discussed in our.
Okay. All right, so then moving on to our next issue. Yes.
Good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins, when we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I
that's
think,
what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so, right when we left court yesterday, when you and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it and we were in agreement?
Yes. That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele and Mr. Sharp. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was in the court.
Okay.
I will speak with them expeditiously.
Okay.
to rectify that.
All right, thank you. All right, so then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed.
Figuring Woody
okay,
out.
things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hylton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we
June
feel
12th.
that that's the applicable law, and that's where we're at.
All right. What about Mr. Matthews? What's
Good morning to the court. On behalf of Mr. Healy, we are in agreement that everything posted in the future file should be taken from her.
okay? And then
Puritan says after the 12th.
Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Same position as Mr. Matthews, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the
I apologize for interrupting the court. I think there was one more party that.
William Stillwell, Kendricks, Huey Ryan. Oh, guess, I don't know. Sorry.
Microphones.
Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it. We
Okay.
have it, and we're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding.
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great.
Uh-oh.
No chewing gum in class.
Law School
All
101.
right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine
What if he's there?
did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
It's a catch-22. Where, how do you solve that?
Listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it. Or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay, all right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of this is or isn't perjury things are a little, I don't think quite exactly accurate either.
Okay.
So I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Okay, so when that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the motion to compel that we had filed, because we got to a point where he's trying to not testify. We would of course ask the court to compel him to testify, and the things that have happened. And he was, as I said, he was represented by counsel, as the court has already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week.
So
And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His father was fired, so no one has said anything to us
Okay.
about a lawyer on his part. So we are unaware of whether he has any
Okay.
representation. And I'd also point out just that since he is still under that immunity grant from the state, my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately
Advised right.
advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are. Would that work for everybody? Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes.
I'll be back from Mr. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
He's
Okay.
reminding us he's still a sworn-in witness.
With respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean, no, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And
He
Your
doesn't
Honor,
want
how
him here
much
today.
How much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor.
Suggestions?
The state is scared of their own star witness.
When the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree.
Get him on a Zoom call today.
Out before he shows up here.
I can have someone who just bring him in. We know
Okay.
where he is, so I can actually ask.
All right. I mean, yeah, if we can find him and even, I mean, I don't care if he shows up by Zoom for me to ask those questions.
Yes,
You know,
Woody on
I mean,
the Zoom.
that's fine with me. All right. So if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you.
I think we're going to end up just going in circles the second he gets back on the stand anyway. Right, you
Y'all
can't
can
undo
think
that
about
witness.
for a few minutes.
So thank you, by the way, to
And
Just a YouTuber and Cambo for
Just
becoming
first
members.
Fields let me know that the 612 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
right here.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if the defense counsel objects, I can send what Mr. Sharp sent us so that the court knows what we're.
What we're walking through.
Yes, Your Honor.
That'd be great.
because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I don't. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay.
Jill Panda, I'm assuming you meant about Adrian Love. She's shaking like Peachy at Magic
maybe
City.
pick up your mic. And y'all, I'm trying, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet, so. It's now on and I am holding it. Mr. Atkins, Miss Love, Mr. Zachary's statement, his statement that I did not review yet or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the AT feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. Yeah, I think yesterday when I spoke, I was expecting one more from you. There are two: the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the August 2017 one. So do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
He's prepared in case Woody can't testify first when we come back. Or she wants them to be, at least. And then G-Lander, thank you. Already speaking in sewage circles. Judge Whitaker doesn't really let her. She's like, I already told you that. And then John Coleman, good to see you. Also with the reminder, thank you so much that likes are free. So hit that like button, you guys. We also have a super sticker from Maricela and $1.99. Thanks for being 100 and for covering for hours. No problem at all. Last night I enjoyed
Transcripts of Zachary's potential, I guess it's statements over at Ms. Persfield or.
Yes, Your Honor, and I was gonna also inquire, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction chart that we discussed.
Okay. Waiting on that to come through and then we'll get started.
Okay, last night I got to sit chat side while I got some work done. And it was really nice to be on the other side and hang out and talk to people, because sometimes it goes so fast in the chat here. I try to scroll and I lose things. I appreciate you, Maricela. Cambo says, how about the fact that the deputy flipped from they didn't discuss anything on the murder, Detective Long? They didn't discuss anything on the murder to, oh yeah, Hylton spoke a few times on that in the ex parte. I thought everything with Long was crazy yesterday. And I don't know why the state, like, listen, the first stuff he said, it kind of seemed like he was helping the state. But once he got questioned, it seemed like maybe he got off track of what he thought he was going to say. He seemed to have gotten lost. And he ultimately did the state no favors with trying to help them show that nothing was wrong about this ex parte meeting. And I really think the judge noticed it because the judge was the one that started asking him a bunch of key questions. So thank you so much, Cambo. Love the picture. And then G-Lander for $4.99 says, the state's arguing Copeland had counsel during the time he was being coerced, while also arguing his counsel was inadequate. Yeah, that is trying to make the argument stick both ways. And this judge is kind of too sharp for that. I don't think this judge is the type to say, well, if I agree with one way or the other, I'll just accept it because I'm agreeing with that one thing. If you're arguing to have it both ways, we need to sort that out because that's contradictory. So, not a good strategy to try to just throw it all out and see if it sticks necessarily with this judge if those are going to be conflicting arguments. But definitely good to note that because she is arguing both ways. And thank you so much, Annie, for the super sticker. Does Love have her laptop down on her lap? I didn't pay attention. Does she not have a laptop today? Or does she currently have it pulled forward and I just can't see it? And guys, remember, Woody was in the court yesterday, ready if they called him. So he was ready to get up there to talk about this Melnick issue and maybe answer some questions about returning to the stand or how he felt about his testimony previously. He was there. But the state, and they didn't want to say it yesterday, they were kind of forced to say it today. They have concerns about calling and subpoenaing, transporting Kenneth Copeland. So think about that.
Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
Court can keep, but this teal colored one is gonna be what we're gonna discuss first.
Okay.
The red may come up later in the next.
Put the red to the side right now, then.
That's perfect.
Thank you.
Oh, and they're cutting us off from sound again. It's weird. The mics in this courtroom pick up all the wrong stuff. And then thank you so much, Mrs. Hemp, for the super sticker. I appreciate you guys. And Brooklyn T. What happens if Woody doesn't want to testify? We're going to go in circles again with, you know, are we going to go through the motions of trying to compel his testimony by threatening to hold him in contempt? Is he going to be willing to sit for the duration of a shorter trial presided over by Judge Whitaker, who wants to keep things moving and not drag it out? It could be the same mess repeated.
Ready with the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a time stamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the most part, I could follow. So if there's a
Okay.
discrepancy, I may ask Mr. Sharp specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
It should be when it ends. So it'll be like 10, I'm pulling up my document.
okay.
Marlena, you got to multitask. You got to work with this in the background. Get some earbuds so you can listen on the go.
It is, I'm sorry. Go ahead with what?
So that first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's in page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at crucial.
Right.
And he can't speak about being at crucial.
Mm-hmm.
I don't have any objection to him speaking about or trying to speak about being at crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them, I haven't synced them up with my transcript and my
Okay.
recording.
So what was the
because
point?
I read the transcript and listened to it so many times.
Okay.
I went through it with that knowledge.
Okay.
I haven't synced it up.
This is like 25 minutes to get through one possible
So I
redaction.
don't have an objection up through line 10. I
Okay.
don't have any objections with it. Page 11, line 10.
All right, so that's out by agreement. right, so that one's out. By agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Sarah, something else anybody needs to take up
we're
before
gonna do a
we
break.
take our morning break and let Miss Love do that?
I don't think she's happy about doing a break
All right.
for this
Anybody else?
right now.
Nobody? Okay.
For 30
All right.
minutes.
We're just gonna take our little morning break early. So we'll be back at 10:30.
Our little morning break. Guys, just no preparation. So she hasn't started responding to any of these outstanding motions involving disqualification. She had renewed arguments yesterday orally delivered by Max Shart specifically, but Brian still got up there and added a little bit more too. They're not prepped on these redactions that they want to do. We just spent 25 minutes. That's my timer here. Since she said, all right, let's talk about the motions in limine relating to Zachary. And what's the problem here? To me, my guess is Whitaker's trying to create a buffer in case, look, if Woody comes up and there's a problem with his testimony, or he doesn't show up, or there's an issue with the subpoena for him, so anything could go wrong, who knows? Well, then we've been saying that Zachary is going to be the next witness in line. So we need to sort out evidentiary issues, any motions in limine relating to what can come in and what can't come in for that witness. This is something she's been saying, like, I think from the first day she had the hearing last week. The very end of the day she mentioned it. Know your witnesses, know who you're calling next. The second day was a lot of conversation about the 3 witnesses, one of them being Zachary. And the state was just sitting on their hands, like they didn't want to be prepared to call another witness because they want Woody first. And here, Whitaker wanted the jury back tomorrow. It's probably out of the picture because yesterday was, focused on a separate fork in the road issue. But they still don't have their potential redactions sorted out for the second backup witness that they might need to call before they call Woody if something comes up. Like, just think about what is the one ask Whitaker has had. Like, let's be productive. And then here we are, not even an hour into the day, taking our little morning break early, a 35 minute break. And the last question relating to anything productive was, well, have you looked at the transcripts? And Love was like, oh, I looked at them, but I didn't line them up. Well, what's the point? What's the point? That answer just means you didn't do what you were supposed to do. Like, yeah, I think she is getting stressed out. You guys are commenting on that in the chat. Otto, good to see you, Otto. Otto will totally make an excuse about not getting Woody. And then also what do you guys think about the transport issue, where it's the state that's responsible for transporting him and making sure he shows up? I mean, it seems like Woody could find his own way, possibly, because he's not currently in custody or anything like that. But maybe he was making them transport him previously to make it difficult for them. Maybe he'll drive himself. But it seems kind of weird now when there's all these ancillary issues, and the judge had to wag her hands at Love, at the state, and say, look, no discussions about substantive matters during transport. Because we know that Love was having conversations with him just about life stuff, but also explaining to him at length how this immunity works. So Hylton contradicted herself. But these conversations were going on one-on-one between Hylton and Woody the week leading up to June 7th. So how would you trust a transport? How would you trust a transport? He's going to borrow the Hellcat that he was doing the YouTube video in and show up, do some donuts in the court parking lot. Oh my gosh. Yeah, just life stuff, Just life stuff that we were talking about. And then let's see. Legally Brown Girl, good to see you. In the words of Jeffrey Williams, pour out their pint, watch it spill. Yeah, oh yeah, okay. My lawyer, Brian Steele. Yeah, he is. So Brian Steele's already in Young Thug lyric. And that was a few years ago that came out already. So Put a 1 in the chat if you think Young Thug is going to release a song in the future that mentions Brian Steele again. Maybe a Keith Adams reference. I don't think we have a Keith Adams reference yet, but maybe in the future there will be a mention of Adams and Steele in a new Thug song. I appreciate you, Legally Brown Girl. And then Aaron says, Woody's new testimony will be making YSL Rico fun again. That's the thing. Everybody is talking about this case. It was Trump went on, I don't know the name, but it's a podcaster or like a YouTube streamer that has a big following and was talking about this case. And it's relevant for him because he has a RICO case in Fulton County as well. But I'm like, that's just got to be another audience that might not be tuned into this is suddenly now tuned into what's going on with Fulton County RICOs. Like, imagine this being your case and everybody from all different walks of life is just looking at it and going, what is this? How is this here? How did we get here? But yeah, Woody's going to come out with new merch with the Making YSL Rico fun again. Terry Hobson says, with the back and further to between the DAs, Hylton being on leave and the seriousness of the Brady, I think Love used yesterday to separate herself. Now, I was thinking about this when I saw this come in. I feel like Love would try to do something like that. Personally, just watching her, the way she is very sensitive, my opinion, very sensitive about things that might be embarrassing to her or personally offensive to her. Even if I can't see the statement as being intended as being personally offensive to her. She kind of seems to internalize things a bit more often than she should. To the point where I really think she would put her arm's length out to try to distance herself from accountability and let somebody else take the blame. And Judge Whitaker yesterday was talking about, I take Brady very seriously. I think we all should. While she's looking over at the state's table. Because quite frankly, the state hasn't taken Brady all that serious. Yesterday, Love's reasoning, Love gave the argument that, they didn't really need equal access. The defense doesn't really need equal access to Brady material. As long as they have some type of reasonable way to get that Brady material. In other words, and I commented while I saw her asking certain questions of Kayla Bumpus, but the idea that Kayla Bumpus may have spoken with defense attorneys at all suddenly means that it should be okay that the defense wasn't disclosed anything that they should have been disclosed to by the state because they had a different means where they were able to get some of the information. And frankly, that's not how it works. That's not equal access to Brady material. Just because someone else happens to mention, yeah, there was a meeting and these things were talked about. And the judge really was tuned into all of that. The judge did not like the idea of dismissing this disclosure issue as just being okay because Kayla eventually spoke to a defense attorney or multiple defense attorneys. And I think you're right on it, Terry. I really think Love is going to act like she did nothing wrong. If anything, it was Hylton and those conversations. I wasn't part of those. I don't know if Brady material was discussed during those because I don't know. That'd be on Hylton. And suddenly, since the judge is focused on this Brady thing, well, the Brady issue, I'm going to make that Hylton's issue. And I think it's grimy because at the end of the day, she's the one in charge of this case. But what do you guys think? So thank you, Terry. Annie, thank you so much for the super chat. I appreciate you. Same thing with Mahadi Jesus. De Jesus, I appreciate you. And then it is Ramon. Shout out to Miss Sylvia. Miss Sylvia can tell Woody to come in today. And then, I don't know, I think that would be funny if Woody shows up on Zoom. I feel like he'll call in from his cell phone. He could be doing something crazy. If they let him call in from Zoom, he might be like with some YouTuber driving around in a Hellcat. It would be entertaining. And I know that's not the point of a trial. But just saying, I wouldn't be surprised if something entertaining happened if they allow him to be called by Zoom today. Thank you so much, Red Bunny. Didn't she tell the state to have their next 30 witnesses? Yeah, and they were able to name like 3 witnesses that they want to call at least for the co-conspirator statements. And I feel like Nickel, Bruce Harvey, right? His client's last name is Nichols. So Bruce Harvey was making an argument one day like we can't redo all this, and the judge, her best response to that is, well, I'm going to try to keep it going moving forward from here. We're going to look at evidentiary rulings moving forward. I don't know, I can't look back and revise previous evidentiary rulings. But moving forward, I'm going to take care of them. So she shifts her attention to the state and says, cool, we're going to sort out these witnesses and what statements you want to bring in. And they are not making any motion, any forward progress on this at all. So here we are. Now, one day before she wanted the jury to come back. And they still can't even sort out the one witness that they squeezed a name out of. Oh, we'll call Zachary. Cool. Make sure you're ready with the statements you want to play. Here we are. Red Bunny, it never ends. It never ends. And I think they've had more than enough time considering they haven't responded to these filings, anything like that. What are they doing? Aaron says, why isn't the lemonade already made? It's Love's MO. It's just Love's MO. And then YSL Love with the green slime nails. Thank you so much, Amber. I appreciate you. And I didn't really notice the nails today. I haven't seen her leaning on her face yet. She's been standing up. Love has been standing up quite a bit today. I wonder, do you think the defense is like trying to nudge away to see if, or the state's trying, anyone's trying to see if they can get Woody to pull up or hop onto Zoom right now? And I agree. I mean, I know we're talking about mistrial. She's going to grant it. She's not going to grant it. She has to grant it. How could she not? But if this continues, can you imagine the different course of just something like Woody's testimony? Because every time we want to try to ask a certain question or bring something in and Woody's not laying the foundation, he is a difficult witness. I don't think that it'll just be waved along quite as easily as Glanville used to wave things in. And now we know that Hylton is going to be on vacation. If court resumes, Hylton's not back. However we figure out the logistics of Woody's testimony, I don't know who's going to be leading the questioning. It seems like he won't speak to Love. So will it be Atkins? Can you guys imagine Atkins cross-examining Woody? How do you think he would do? Especially, he's going to be a difficult witness, and they need to get these certain statements in through these calls and videos, depending on what they have to redo. It's going to be a mess. Like, it's just going to be a mess. Oh my goodness. Oh, and thank you so much. So Heart of Inspiration, I noticed because Otto screamed gifts in the chat. I love when Otto yells for gifts. That's my favorite thing in the world. But thank you so much, Heart of Inspiration, gifting 10 memberships. You guys all say thank you in the chat and take advantage of your new Mario Kart member emojis. You guys can join the race. Thank you so much, Heart of Inspiration. Good to see you. Q, thanks for the super sticker. Although I'd love just seeing the towel-y picture. Great question. And you know I love reading super chats from my favorite name, Big Tit. Why does the state get 3 days to respond to motions? I mean, I guess there's new stuff that has happened, but there's still motions that are older than 3 days at this point that they haven't responded to. So I think it's longer than 3 days. But if Judge Whitaker is being kind and saying, look, there's been some new stuff, it kind of overlaps, just respond to all of it. We'll give you till Friday. I think the only reason they're getting that grace is because the judge is going to be out on Friday anyway. She said she had something pre-planned, like an appointment before she took this case over, and she wasn't going to be here Friday anyway. So I'm thinking she's leaning towards not having the jury back until Monday instead of calling them in tomorrow or Thursday and then making them take a break again. So I think they got that grace just because we're not going to resume until Monday anyway. So Whitaker would at least have the weekend to look over everything. But I think if that wasn't the case, can you imagine if Love still didn't have a response, but she wanted to get the jury back in? It would just hold everything up. And I think we've seen Whitaker point and give a little slap on the wrist about people not being prepared, the state not being prepared. But I think there's a little bit more simmering behind in the back of her mind where it's tallying. She's tallying it up in her head that, all right, they're not prepared again. All right, they're not prepared again. All right, we're holding the jury's time. We're wasting the jury's time even more because they're not prepared again. And I think at some point, all of that snowballs. And we'll just have to wait and see. But you never know. There could be a big moment where she just lashes out and says, look, you keep doing this. It's not right. And I want to see it. So thanks so much for the super chat. And then Danielle Sky Eagle says, how can the state legally put Woody on the stand knowing he's lying and said he will lie? To be honest, I don't think Woody helps the state's case at all. I think the most beneficial thing for the state is the fact that Whitaker's making them whittle down these jail calls and detective tapes. I think the jury, they want Woody in to get these tapes in, but they tried to play like 8 hours worth of tape that nobody can hear or pay attention to. They were falling asleep like, was that Lil Rod falling asleep in court nodding off earlier today? That's got to be what the jury's doing when they're playing these 8 like long, low quality calls. Because that's how it feels when I'm watching it on the other screen here over here. So I feel like they're just putting him up there. They don't care if he says he doesn't recall. I think it benefits them if they think he's giving an inconsistent statement, because then they can, hey, no, that's not what you said in this footage. And now we get to play this footage. So I think it's strategic. I think they want him to lie. I think it helps them. And some states don't allow that, but I think Georgia apparently does. But some states you can't call a witness just to impeach them. But in Georgia, apparently you can, and they're using that as a strategy, I think, to kind of barge these video clips in, these prior statements made to police with all these hearsay, possible co-conspirator statements. So I think it's strategic. I think it's an advantage, a +1 for the state, that the judge has forced them to whittle down those long clips. Will the jury sway one way or another because of Woody's actual current testimony? I don't know. They get to determine whether they think someone's credible and what they're saying is credible. So I just don't see it personally, but thank you so much for the super chat. And Sunshine, thanks for the sticker. Good to see you, Sunshine. Okay, wait, so Woody's at the courthouse? Hold on, you guys. Is Woody at the courthouse? Wouldn't it be funny if he has like an Instagram live story? I wouldn't be surprised he was there. He was there yesterday. And it's funny. The state's acting like, oh, we don't know if we can get him today. We don't know. Maybe tomorrow. So we have time to think about how to panic. How broad is your inquiry going to be of Woody if we get him in on the stand today or tomorrow? You can tell by those questions that Love didn't want Woody to get up on there today. We want to call him as a witness, but we don't really welcome an inquiry about, hey, did you feel like you were coerced into testimony? We don't welcome that. We want to subpoena him and make sure he shows up next week for the jury, but we don't want him today or tomorrow. But yeah, so I would not be surprised. I would absolutely not be surprised if he's there. I'm trusting you guys that you're getting word that he is in there. Don't call me to testify. I'd be nervous on the stand. I would definitely be nervous on the stand. You'd be like, what's wrong with her? Yeah, and don't forget the star witness. Okay, so DCP, yeah, you guys are saying that he's there, so there we go. Well, and this is the thing, Khalil. So people keep forgetting Woody's a snitch, but I think the jury can kind of surmise that if they want to. If they're following along and they want to come to that conclusion, they can look at those videos and think that's exactly what those videos are. And then to hear Woody say, maybe they'll reverse that testimony, but I don't know how far they'll actually walk it back. Maybe he'll testify to the same thing again if they start from scratch. But Woody's saying, I told them whatever they wanted to hear so I could get up out of there. If I was sitting on the jury, I'd be like, right, so, like, maybe snitch is even the right word. Because snitching kind of implies you're telling the truth about something that went down behind somebody else's back that wouldn't expect you to tell if asked. I feel like Copeland, he might more just be talking to say anything, kind of like he's saying he does. I don't know. I feel like the jury has those two paths that they've got. I don't really see how they conclude much else about Copeland's testimony. They're either going to think he's a snitch, but telling the truth about what he's saying back in the present day. That was a bad term. Back in the day. Versus presently, they might buy into him saying whatever he said to protect people. Or to just get out himself. Kind of throw someone under the bus just enough, where it wouldn't be enough that they'd actually find the right person, but it would look like he was telling them that person did it to get them off his back and get them off other people's back, and just kind of like rotate the focus. But that's all in the jury to decide. And the jury could be just like people here in the chat. People that think he was a snitch but telling the truth. People that think he was never telling the truth and just trying to get out of there. JT Coinrings, good to see you. How are you? I know you do YouTube. I catch your videos sometimes. So I'm going to have to pull up your channel. But I am so uneducated. But I tune in and I try to learn from you, JT Coinrings. I really do. I'm just like lost though. It's like earlier in the chat when I was talking about Blue's House. I don't have time to watch movies, so I don't really understand. I like to follow how companies develop stories that already exist and they want to make them into movies. I kind of like looking at that from a production standpoint and a business standpoint, but I don't really know the backstories of these comics. So I get a lot of that info from Blue's House. And JT Coinrings, there we go, just dropped his channel in the chat. You know, I know nothing about like jewelry, precious metals, anything like that. But you hear, hey, it's a good thing to have precious metals. And my family, you know, they try to gift jewelry, like passing down. My grandparents, when they were getting older, they're like, here's our heirloom jewelry. And I feel bad because I don't know anything about it. And JT Coinrings talks about all of that stuff. So super awesome. Good to see you. Thanks for becoming a member, Big Baby Jane. And then Mark Lyon. So is YSL Love secretly using the power of the state to promote and enhance the gang? Should DA Willis add her as a co-conspirator? I really don't know what I think is going on. I think it all comes down to them wanting to prosecute somebody for the murder of Donovan Thomas. And I think they may be relying on anecdotes or maybe spilled beans to get themselves there. And in doing that, they decided, well, hey, why don't we just use RICO and block a bunch of other crimes and indict a bunch of other people along with it. It'll look like a much bigger shebang. We'll look awesome. We'll look like we're reducing the crime rate. We'll prosecute all these big bad people. Just throw it in. Just add more layers to it. And I don't know. Because a lot of people are wondering why we have someone that was listed as top 10 most dangerous people in Atlanta and Fulton County. He's got immunity just because the state wants his testimony. And because of this whole ordeal, we've had Love had to say on the record multiple times, we don't plan to prosecute him for anything. We don't plan to use his words against him. But since they're prosecuting such a large scope of things, they're asking Woody about an extensive period of time. a time period that encompasses multiple potential criminal acts. And they're saying all that stuff we're going to question him on, dating back years and years and years, we're not going to use any, and if you take them at face value and trust that they're not going to use that as a lead, and then pretend they had another lead and that it wasn't related to his testimony, use immunity is only as good as you can trust it, in my opinion, because I don't trust Fulton County to say they're not going to use your testimony as a lead to prosecute you down the line. But they're basically saying anything, this huge scope of what we're trying to prosecute that expands years and years, anything you testify about those things, if you were involved in any way, oops, you've got you possibly could have been involved in all of this stuff. We're not going to prosecute you for any of it. We're not going to chase a prosecution for you for any of it. So think about what that means. I don't know if Love planned to do that or if she just kind of found herself here. I don't think it's helpful to the county. I don't know why with Fani Willis, why YSL Mondo wasn't part of the indictment. I'm not saying maybe he should be sitting here as like a 7th co-defendant on this exact trial, but he wasn't even indicted. It wasn't even like he took a plea and got to plea out. Just wasn't even indicted. Co-conspirator of YSL. But Fani Willis used to represent him. And it's just weird. Because I've always wondered, did they get information maybe from, not as in YSL Mondo was necessarily snitching, but through the course of Fani Willis representing him, is there attorney-client privilege information that Fani Willis kept in her back pocket to say, hey, you know what, this YSL, why don't we look at this, this, and this, and this, and this, using that information that she acquired in her course of her representation of YSL Mondo to then use to prosecute this RICO case. I don't know. I think there's got to be something more going on. I appreciate the chance to ponder on it, the food for thought, but it's only speculation. Thank you so much, Jeanette Hughes, for the super sticker. And then, yep, Otto, that's exactly it. I think, that's my opinion. I think a lot of this basic info, where we're going to look, what we should look at, came back from Fani in her capacity as a defense attorney for YSL Mondo. Again, all speculation, but logically, it makes some sense. Makes some sense. Yeah, and you guys, maybe she was only representing him to get the info. Kat, fellow Kat, good to see you. Or maybe it's KAT and stands for something individually, but good to see you, fellow Kat. He was definitely snitching. So this could be about Woody, it could be about YSL Mondo. But that's the other thing too, help get me out of this, self-serving statements, and then those self-serving statements get used by someone on the prosecution team to prosecute somebody else. And then, yeah, we've got, the parallel stuff going on with the YFN Lucci case. And then let's see, let me go back over here. So Red Bunny, thanks so much, says, I honestly feel the judge is waiting to see if the jury causes a mistrial first, as in we come back, yep. So it doesn't fall on her to make the decision. Great point. Because I've had the idea that the jury could just fall out. This is a trial of attrition. We have a limited amount of jurors that were seated, a limited amount of alternates. Some of them have had to drop out already. We've been gone for 2 months. Approaching 2 months. What if the jury comes back and 1 or 2 need to drop out? What if we come back and half the jury is like, I've been watching this case while I was gone. How could I not? Even if I tried not to, I still saw stuff on it because I couldn't help it. It's everywhere. Like, I was outside and I saw Woody doing donuts in a Hellcat while I was at the store. Like, and then people around me started talking about the trial and how the judge got recused for misconduct or for this meeting that he had. Like, it's so hard to avoid. Imagine if half the jurors are like, yeah, we gotta go. We heard about this case. Or they're over it. Do you think it would be wrong? I think sitting as a juror is a noble duty. It's a great thing to do. But would you think it was wrong if a juror at this point in this trial exaggerated or got hyperbolic with, maybe they didn't really look at the case, but they're going to say that they looked at the case and that it's going to impress upon them in a way that they can't forget, and they're going to look at this trial through a biased lens now? Would you blame the jury if a juror exaggerated to get off of this case at this point? Would you have some mercy or grace if they did that? But Red Bunny brings up a good point that maybe the judge is specifically waiting to see what happens if the jury comes back, because maybe she's thinking the same. And she still has, that's Bruce Harvey's big argument. Doug Weinstein made this argument. You can't just undo all this change, this mid-trial substitution of a judge. How are you going to get over that? Oh, you can't tell the jury not to think about Dumbo and expect them to not start thinking about Dumbo immediately. You can't tell them to forget Woody. You can't tell them to forget Glanville, because they're going to think about that. So I really think this is a great point, Red Bunny, that maybe she's looking at that as a way to find another way to get a mistrial, let it be on the jury, rather than calling prosecutorial misconduct. And then Jennifer Matthews Stewart, thanks so much for becoming a member. And then Aaron, yep, so that's a great way to put it. What do you guys think of this characterization? Woody's immunity is a Trojan horse. Just make sure you can make him barge that testimony through, get enough foundation or enough of an impeachment or contradiction that you can get these videos in by any means necessary. And the immunity deal's tucked in that Trojan horse and was waiting that whole week leading up to June 7th. So thank you so much, Aaron. I appreciate it. And then, yeah. So Saj, shout out to you. You'd stick through the entire thing. And I think I'm in a unique position because I work for myself. Like, I am, to some extent, you guys have heard me talk about that as soon as I'm doing something dedicated, that's when everybody wants to call and do a Zoom call. But besides that, I'm covering this during the day, but at 5 o'clock when we shut down, I just go and finish up the work that I do. I'm working on my computer from home, doing data entry, busy work, tasks, making sure I do my copywriting, setting up email campaigns or whatever. I'm in a unique position where I could find a way, if I had to sit for jury duty Monday through Friday, I could still find time to get client work done, right? I wouldn't love to do it, but I don't think it would put me in a situation where, like, holy moly, this is really messing up my livelihood. So I think I'm lucky in that I wouldn't be in that position. But I think if I couldn't find a job, or I lost my job, or I wasn't able to return to work because this case they're calling us back tomorrow maybe, or nope, not anymore. We didn't know that we're going to have a 2-month break. I didn't know I could tell my employer I could work for 2 weeks. Maybe I'm not even employed anymore, but I can't look for a new job because I got to tell them I don't know when I can actually start. I don't know. I feel like the duty becomes an infringement upon your own life and liberty if the court is wasting your time. And I think it is noble, no matter, maybe we want Judge Whitaker to rule a certain way a little bit here and there, and we're like, oh, she didn't rule that way. I do think, like, she and many other judges I've watched, not Judge Glanville in particular, but really respect the jury's time for this reason. You don't want to bog down the role of being a juror by stomping on a juror's, livelihood, stomping on their personal freedoms, holding them down for months and months just because the trial is messy and unorganized. Michelle, I think we're only down to like 3 alternates. Don't quote me on that. But I don't think we have many left. So, because we've already lost some. Yeah, it is Ramon. Oh my God, a 5-year trial. Ugh. That would do it. But maybe it was spaced out. Maybe it was manageable. Like maybe we need to stop for like a year. And we've got some movement. We just swung the camera over to the flagpole. And yeah, so Melissa Watson, Willis wrote a letter vouching for Lucci to be released, which is kind of like, all right, reducing the amount of heads in beds in a jail or prison system could be a noble and progressive cause. But at the same time, that seems like a weird thing to do when you've got people in Fulton County sitting for more than 90 days without an indictment. So maybe start writing these notes to the court that you're required by statute to write when someone's been in custody for more than 45 days without being charged, without being indicted. Maybe start writing those notes too. Because if you're writing this letter for someone you tried to prosecute through RICO, but you won't write these notes for everybody else, that just doesn't seem balanced. So it doesn't pass the smell test to me, personally. Okay, so that was in his plea that they wouldn't object to his first parole. That's a good detail. Yeah, I think some of this, again, it's offensive to the jurors. And I'm sure at this point that they're just used to it, right? It's not like this fork in the road 2 months ago was something new or different about this trial. There were other times where like, oh, jury, we're sending you home for the day randomly and don't come back tomorrow because we have this issue that we have to handle mid-trial. So it's not really the first time. Yep. So John, the length of the trial makes it unreasonable for any juror. And during voir dire, the hardship question gave a time frame of 3 to 6 months. So, and jury selection took more than 3 to 6 months. But even once the trial actually started, we're more than 6 months in. We're already past that upper limit. And we're estimating, optimistically, 30 more weeks. And I think that's very optimistic. I think the judge might be realizing that was optimistic. Even though I think she was determined to make it 30 weeks when she said that, I think she's realizing that's out of her hands. And then thank you so much to Mahadi. If Woody's in the court, can he request an attorney? Yeah, and I'm sure there's other attorneys. I mean, that's got to be a busy courtroom, so you never know. He could find somebody. We'll find out. So if they bring him in and we see they will inquire. It seems like they're going to inquire because was it Carrington Matthews? Someone spoke up. Someone spoke up saying they wanted to inquire on Woody's counsel. So I'm not sure who it was, but somebody on the defense side said it. They didn't pan over to him. And then Tanika Battle, thanks so much for the $4.99 super chat. And I'm going to pull up, while we wait for this court to resume, we're 4 minutes late now. I do want to check, see if anything's been filed.
Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but he's already given the court the first one. Does the court have a copy of his redaction?
Yeah, the proposed redaction, yes.
Okay, so looking at Mr. Sharp's chart, number
Thank you,
one,
Stephen.
number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of the defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should not come in.
All right.
As well as number 19, which is on page 73 of the transcript.
All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry.
I agree, Ms.
Mr. Sharp
Kim.
has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Ms. Lowe, could you just give me the number of the second one you had no objection to?
17.
Here, microphone.
So 17 and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to is?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right, so we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep that all the way through 9422.
Come on, love.
9211 through 9422.
Yeah, he did the right thing
That's what
by,
I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or
All
I
right.
can.
Let's do that right now, and
All
then
right.
over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did
Okay?
Did the state agree to 27 or no?
It's,
No, we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
well, sounds like they're not ready. But yeah, Melnick did the right thing by not wanting to keep it a secret that he knew his client planned to plead the fifth. And personally, I think the state's issue was that Melnick wanted to make other people aware. And this is exactly it, Michelle.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yeah, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up the house.
Thank you so much, Joel. Or maybe you go by Joelle. I need the phonetics in the chat. Thank you so
Page
much for this, the
13,
25 to keep
line
up the good work.
16 starts at Dennis talking with the witness about the house getting shot up, and this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection is speculation.
So my argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D-Fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the,
Okay.
granted as to speculation.
Okay,
And if you establish it,
okay.
then that'll be a different story.
That'll work.
So many rulings on the evidence have gone this way for the state. If you can establish it,
14. Okay, so the next one being page 25. So 25, page 25, line 9 through 2512 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay,
And what they were doing, it's an admission.
all right.
It's an admission against his.
All right, so what's our objection there, Mr. Short?
My objection is drug use, and the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to the, they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is,
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
all right, Ms. Love?
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. You know, it could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think, I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, you know, wait, you.
right. What's the motive? The motive's just they were high.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is
I think subject to foundation is going to be different from this point forward. Well, from whenever Whitaker stepped in, point forward.
So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25.
17 through 20.
Yes, I'm sorry. So 17 through 20.
Right.
He's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that we were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes, so.
So Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in his proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachary can speak to his own intention unless he says, Mr. Stillwell was there and this is what Mr. Stillwell said or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked what was y'all's intention, and that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All
that they
right,
are
so
having
where's that?
conversations. So up. On line 4, he says, because he said we're not gonna shoot, how to be that to them. So on line 2, Investigator Dennis asks, why does Moontoon, and that isn't actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's
Line 9.
talking about what Moontoon said. Moontoon's not even here. My client is not Moontoon. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Moontoon telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It
Okay.
is. Okay, so assuming you need to use it as a prior inconsistent statement. or-
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
So Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right,
25.
28, line 17.
The
No.
font is a little small. I'm sorry? I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this incident. The
So
shooting of
this
the houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been.
Did somebody get shot at this house?
Yes.
And that evidence will come in through this
The-
other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot?
Yes.
Okay, so then that is all right. All right, number 6. And I guess let's make this 3-page proffer of proposed edits a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
Okay. So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line You can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it
How
just
would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it
don't,
out. Strike it. Granted.
you're, okay.
Yeah, don't argue after she said it's already. She was about to keep it going.
Out.
And G-Lander, with the Xanax, I'm sure as long as it's appropriate, they'll question on him, you know, maybe
I'm
he
just
had it
writing
illegally.
August
Maybe it was
6th.
prescription.
August 6, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Monktunk, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah, and they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindaria Zachary about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was kale, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17, where he says they tried to say that we did it on on page 33.
oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish
the existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
all right, Mr.
So,
Sharp.
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe. I don't know.
with
I
this-
know they're all annoying. They get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who, you know, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't have, I mean, I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 150262801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's
associate of YSL and a member of YSL aren't the same thing.
They aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person.
Go ahead.
she does.
So
All right, let me.
so if gang is the gang that
So
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant in this case, Mr. Zachary, is actually saying they were wrong about, how's that admissible to anything? You know, and if that's the key section, that's inadmissible of itself, in itself. But I think this whole section is just wholly irrelevant and it confuses the issues.
And if the court goes on further down, and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right, so.
He's literally saying, no, that didn't happen.
Right, but she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, you know, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, you know, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you know, you and whomever were involved in this shooting with the, you know, whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other words,
says
don't
something
try to
different. You're like,
don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Thank you, recused Judge Glanville in the chat. You had a dinner / ex parte yesterday with Whitaker. She's back on our team, so no mistrial. And I'm not going to claim IFG here on this chat, but I'll leave that to recused Judge Glanville.
36.
And Jennifer, they gave you yellow on my screen. I don't know if it's the same for everybody.
Number 8 being page 36.
But thank you so much, and you are so welcome. I also
lines
love
1 through
purple.
30.
I'm sorry, I hadn't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
We're not going to talk about people not liking
And,
Detective Gaither.
Your Honor,
And that-
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8. So,
Okay.
all right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
And do you guys know if Trevante is Woody's best friend that passed? Because one thing about me is my names. I am
So
not
there-
good with names.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot
All
up.
right. Is
Okay.
that
Yes to
relevant?
Trevante being the best
So,
friend. Thank
Judge,
you.
In context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
Correct.
Okay.
So I'm wondering if that's a part of the reason why they really want Kenneth Copeland up before they call Zachary.
For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right. So that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because
Let's
this
not wait
happened.
till the last minute to do it. Okay.
It would only be by virtue of something happening on the stand.
Okay. I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mm-hmm.
Okay. So that's lines 3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay. Well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. Line 8. Okay. Through 39, 11.
Really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about Tay, people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in about Tay one way or another.
Right.
But I'm just trying to limit confusion that the
Right.
jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right. She may agree.
I have no objection to 8 through with the clarification that he made, because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay,
of
so,
page 38.
all right.
And then on 39, uh, 30 to 3919, 1 through
39.
19.
39-1.
39, 9 through 19, or
1
just
through
all?
19.
One, okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then they
yes.
start talking about Tay shot Kel.
And
I don't. Again, I don't represent Tay. Tay's not associated, so, but it's just I just
Right.
think it would be
He is-
confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who is dead and not on trial here, right?
That's true, unfortunately.
Okay, so is it relevant?
In it,
Give it up, love.
I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this
Do they?
relevant to the story the state is attempting to tell?
yes, it goes into, over into page 40. There's a video that we're gonna have about with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're
Okay.
saying they're talking to Shell Kell, who is If Gang. And they have, I think that they have a gun, that's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mhm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's
After all
gonna be
that.
15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary
We don't.
saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right. Hang on. Ms.
So-
Love,
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Antrevia's house, that part is correct because Antrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that that would be relevant. It's not, it wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up. It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevious house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevious Smith's house. Mr. Zachary was not shooting at Trevious Smith's house or being shot at Miss Smith's house, Trevious Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shell Cal was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right, let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
We're approaching an hour and there's only been like 5 statements. Maybe over 5.
And that's all the way through 42.
But some of them were like non-decision, like most of them were non-decisions. Subject to foundation being laid. Or right now, come back to us on that one. Or never mind, we don't even want to try to get that one in anymore. And Cash Money Cast, thank you. The ice cream cone with the tan on the bottom and the strawberry on the top.
So the next one is number 10 is 42. Line 17 through 44, line 6. What is it? So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have gotten in, we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car, Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. I mean, that seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our
Okay.
objection.
Okay. All right. All right.
So I'm take that out.
All right. Number 11, 45.
That should,
Or 15.
number 11 should be 46, line
Okay.
15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45.
Okay.
I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have
All right,
no
that- she
objection to that
agrees.
part coming out. Mm-mm.
Okay.
What's her name?
So
That's
that's
45, 15 through 46,
Yeah.
16. I agree. Okay, let me interrupt y'all a minute. I have word that Mr. Copeland is here and available
we go.
right now, so why don't we pause what we're doing with this?
Copeland time.
And have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
Scale of
We-
1
we
to 10 if you
could,
think this is going to be interesting or not.
get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But
Oh,
I
so lunch
could at
first.
least find out about the attorney issue right now. Okay.
Here we go. I don't think she knew he was coming. I think he found out and showed up. Do you think Love asked him to come in today?
All right, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters. But I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know when to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether.
said I was talking to Melnick, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that
This
actually
is gonna go
occurred?
well.
I don't believe it occurred.
Okay.
I believe that Miss Bumpus,
Yes.
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Miss Bumpus was relieved. But
Yeah, I know
don't-
she was,
There was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe we,
There was, Miss Bumpus actually said, yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that, he could either exercise.
That's not a
his, you know,
paper
well,
sign.
choose
One
not to
thing-
testify.
Right. Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so
Dang, Melnick's gonna
I'm
come
going
in
to try to
scorched earth,
get a hold of Mr. Melnick and see if he can be here with us this afternoon because
or he's gonna try to withdraw.
some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hylton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and do
So if I don't
that
testify,
over. Huh?
so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state.
What did we say?
Did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so
came from.
I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah. Because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or
Tell us who reached
potentially
out.
tomorrow instead, okay?
All right.
All right, thank you.
All right, we're gonna check his Instagram because I feel like he's gonna say something on Instagram.
So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority
Yes, Your Honor.
lets you believe that. Okay.
So why don't they know that
All right,
already?
yeah.
One thing.
If that's real.
I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday.
Mhm.
she was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said,
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress.
So
which
we got
is
like
good.
20 minutes. We'll catch up on
All
these
right, so
chats. We
were
have a lot to talk about. All those evidentiary
number
issues on
12.
Copeland are just, whew. Thank you to all the new members, TGG Gaming, Ms. Kims, and the Nick Farrier. During lunch, Black Butterfly will scroll back and rewatch this, about 5 or 6 minutes where Woody walked in and
Number
watched the
12
body
being
language.
Page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay. So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, that we would argue it's Mr. Zachary's knowledge of gang.
Is the sound back, you guys? I rewound it about like 30, 40 seconds.
Line to exclude it. Assuming that.
Just redid the screen
court
share.
is
Let me
satisfied
know.
With the foundation that the state lays for Mr. Zachary's
Being
ability
a
to.
co-conspirator.
Yes, we would argue that it's admissible. It's.
So do you know whether he was there or not?
So.
So let me ask Mr. Sharp, is the basis for you saying you don't think he was there that no on line 23 when, is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no, no,
Okay.
it's not based on that.
Okay. You have no
actually
reason
do
to
not
believe.
know.
Okay,
I actually do not know if
Okay.
he was there, and I haven't heard anyone talk about him being
okay.
there.
Do we
And
know
I-
whether
and
he
this
was
is-
there?
Page 48, line 5, start line.
Oh, so we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And then
I would
somewhere
draw-
else he says, would he, okay, all right, well then you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donna and Thomas. Zachary repeats the question. Ultimately, Zachary says, shoot, they say Woody and them, I don't know for a fact. So I would agree and argue that he don't know.
Okay,
So it's
He's
not,
telling them,
okay. So 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relates to law enforcement about statements made to him by two people in the courtroom now. And two people admitting having killed Diamond Thomas.
Okay,
This statement right here is after 2 years later. So, when he says, they say Woody and them, I don't know for a fact.
mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay,
so, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually, in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay,
So, if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
mhm.
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know.
later on, he says, my client directly said this.
All right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see who
He
you,
is
I see what
holding-
you mean.
Yeah.
If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him
Okay.
at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
All right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think.
right?
ask
So,
Who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they.
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511, is that all gonna be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22?
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that,
All of that, we would object to it being redacted out. All of this is Mr. Copeland talking about.
okay, so, all right. The,
Not Mr. Copeland, Mr. Zachary, not so I don't know how.
okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, no, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here, because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
In this particular interview, no, not as it relates to.
Oh, good
this
Lord.
Statement right here. Because it's one of those.
It's all over the place.
No, it's, as it relates to the way that Dennis is talking to Zachary.
Yeah.
He means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video
Okay.
of this part, because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked. But if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds?
I
Okay.
believe so.
Thank you.
Per my notes.
Okay, thanks.
And then, do you guys remember anywhere Melnick saying if my client testifies, I'm withdrawing?
So the next one or just?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now.
Because I
I'll
think
take a
Love
look at
pulled
that
from Ashley
offline if y'all
Merchant's
will send me
language.
that video. So yeah, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right.
I have 3 digits. I know it's meant to be a typo. Probably is it just 5722 to 5723? Because it has 223.
I think so. Your objection, Mr. Short, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is.
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but
Right.
I can understand that. You wanna agree to that, Ms. Love?
Judge, is the court will give, my counsel is sitting here whispering in my ear, the court will give you 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm hearing you, court.
We'll see. All right, I'll give you about 10 more seconds to make your decision, then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection. 14, and then 16 starts at page 66. Line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12 starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then Investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count 1 and the gang count in this case.
That's not my issue.
Count 1.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontoon or that's Moontoon's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's mom's house. And there's a couple reasons. It's not Bennett put in evidence.
Okay, well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So
by
really 16
redacting a smaller part of it.
I should have said 16 to 17 if I was to be more precise.
Okay, so any issue with just with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quindarius Act. No objection at all.
Okay. So. So that's 66, 17 through 18. Out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was.
yeah.
Was the court asking?
I don't, Mr. Sharp, did that have some issue?
Right, 60, they're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know until you went to court yesterday. So I think that should come out 6819.
Okay, so that's, and then maybe we just aren't lined up with line numbers.
Yeah, that's my.
So 68, 19 through 21, right?
I would say.
25,
Because then they go to Lucci mom again.
well, 24 maybe?
Right, okay,
Okay, like, right?
yes.
So 19 through 24, out.
And then,
All right, hang on, let's make sure that we've got agreement on that.
So 19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shootings on it. You know, it's one of the guns used in one of the shootings. So, even though as it relates to the previous portion that I
Uh-huh.
agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's Motu's gun. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says, it has shootings on it. Yeah, it has some shootings on it.
He says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so that would be lines. So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that. All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, so halfway through too.
Okay.
Through 5, really.
Was that page 69, line 2?
Yes.
Yeah, lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so Judge, when Detective Dennis asks who shot up Lucci's mama's house on page 69 at line 25, and Mr. Zachary gives them an answer. I would argue that all of this is information that I should be able to ask him about. And if he doesn't, if he testifies inconsistently, it should be able to come in. I'm not looking at his reason for asking it to come out, so I would.
yeah, what's your,
There's no indication,
how he knows?
to the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says, I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on. But I don't believe he's going to say that and he needs firsthand knowledge or another exception or another hearsay exception. And and I don't see it, and the state just kind of saying, oh, well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case. And I think that the investigators, I'm not trying to criticize them, but they're just trying to like gather information, not in preparation of trying the case, but just trying to get like some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we would ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Thug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I just think, I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Well.
so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be to say who did it and then didn't you tell them. I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, you know, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right?
She doesn't even know after
I mean,
arguing all
obviously, if
that.
he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge, you know?
Yes.
So I don't know if we'll swing back around to that one. Okay.
Her argument is basically like, Your Honor, we've done this the whole rest of the trial, and this is how we expect to continue to get things in.
I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation regardless
all these
of
statements.
as to his testimony on the stand or as to this, you know, but yeah, it kind of let us know what that's going to be so that I can make a determination of whether it comes in, you know, potentially. Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then.
Oh boy, we have a lot to talk about. You know the drill, we gotta make sure they actually go off screen.
All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, you know, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
Paging Mr. Melnick. Aaron had said for $4.99, thanks for the super chat. Get on the phone with TLA. Send him down to save Woody. Can you imagine if you see someone like TLA or who are some other Atlanta attorneys just going up in there and they're going to represent Woody? I mean, that's not TLA's specialization, but somebody get in there and represent him today. And maybe Melnick's in a hearing, like busy doing something right now, but he'll answer his phone. Maybe he's in the courtroom somewhere else. I guess they probably know that, though. Amber Down, thanks so much, says, or Amber Dawn, says, Woody the Fifth spread the hashtag, y'all. And then did you see Love's face when she said Woody's here? So guys, I think we should rewatch that during lunch. The like 5 to 6 minutes that Woody came into the courtroom. And we can watch again with the second pair of eyes and see what goes on. So let's do that after. I want to shout this out. Thank you so much to Mahadi De Jesus. Sends a 50. That's so nice of you. This was a great move by Woody. Guys, put a 1 in the chat if you think Woody coming in and Judge Whitaker just doing that quick inquiry, if you think that that was a good move for the defense in this case. Put a 2 if you think it's going to go well for the state. But Mahadi points out that this is a reset for Woody and the immunity. And we get Judge Whitaker on the record, to I'm sure the state's dismay, to say, look, there was some false information that y'all gave him in this June 10th ex parte as far as how this immunity coverage works and his protection. There was some false information given. That's not a great thing for a judge to tell you. It's really not a great thing. So thank you so much, Mahadi. We are going to go back and look at that. I had bookmarked this earlier, and I think this is a great thing to mention. So Ms. Nikki, thanks for the $9.99, had said, is it proper for judges to consult other judges while presiding over a case, especially consulting on how to decide certain motions? So yes, judges can confer with each other. They often do for scheduling issues if they're in the same court, but they can also go to each other for advice on, you know, is there authority here? What would you say? What's your insight? But at the end of the day, the judge, the seating judge that's presiding over whatever case they're talking about, is still the one that's supposed to make the decision. They're not supposed to abscond their role to a different judge. So they can get advice, but they're not just supposed to go to someone else to make the decision for them, if that makes sense. So great question. Shout out to Mason Martin for the super chat. No message, nothing, just a super chat. I appreciate you. And then Chance, good to see you, Chance, says, Kat, you're the bee's knees. Keep up the good work. I do believe it's far past time for a mistrial. Steele was right yesterday when he said there seems to be no consequences for the state's conduct. And again, that inaction essentially ratifies the misconduct. By doing nothing at all, you're essentially saying it's okay. You're making it okay. And I see you guys have a ton of 1s in the chat. Ton of 1s. So yeah, you guys are right on board thinking like, Woody, this is better for the defense. And thank you so much from Nick Starro. So you're still live and stream sniping. So everyone wave to Nick Starro's chat. What's everyone having for lunch? We're going to get to that clip, but I do want to jump back to, we've talked about it on this stream. I've seen it talked about kind of a lot on a bunch of streams. Everybody looked at it when it was first published. But back in June, Woody had made this post on Instagram. In all caps. He is an innocent man in real life. The demons that has been on me at certain times in my life had full control. It took years to break free of those demons, and now my conscience is eating me up. I'm not allowed to, and it's like the talk emoji, but I pray to God that they pray and trust in him, that he reveals everything that's going on. Every single person that steps in that building. What building does he mean? Every single person that steps in that building have been violated, and they show us time after time that they run everything. I lost family members, my kids, and at the point of losing my sanity. Now there's 2 smaller blocks of text that says, this is not freedom. This is a country that bullies others to comply. This is a country that takes what they want. And this is a country that will not stop until they get what they want. And the other paragraph says, now come lock me back up. I ain't scared. So Thugger Daily had just done a flashback to this post. A lot of you guys will remember it. If you haven't been paying attention, if you're stepping into this kind of new, what do you think about this post from the end of June? And what it might suggest about how Woody will testify if he gets back on the stand. Boosh McFadden says the building is the building of love around his heart. Well, yeah, you guys, the courthouse. Now let's go watch the clip. We're going to rewind. Let's go find him back on the stand. We're going to rewind to right when they say that he's here. Let me put a banner so people aren't confused.
Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay, the first, well, right, want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no.
She was looking at him, but looked down as soon as he looked.
But
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
I'll listen to her answer.
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was.
There
but-
was nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was, Ms. Bumpus actually said yesterday, I believe during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Ms. Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hylton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify,
Huh?
so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so
And that part bothered me because they apparently did their homework between June 7th and June 10th to figure something out. They came up with the solution. We didn't explicitly hear what that solution was, that thing that lawyer love loves so much about this great law that we have. But we know on June 10th, they come in and say, well, we could hold you even longer than this trial. We don't hear the authority mentioned during that ex parte. There's no reason to mention the authority out loud if the judge is already on the same page for whatever reason. But if you had done that research to find that way, why aren't you aware of the authority right now, present day, when you know you're still struggling to call this witness? Why might you not be aware of the authority that you relied on to say this thing you said on June 10th? If you made that up, and you can't find that now, and you also gave false information, how will Judge Whitaker not see that as coercive? Especially, and the defense attorneys have made this argument, this is an experienced attorney. Hylton is also an experienced attorney. The judge also should have known. If there is no authority because they made it up, how do you not say that they knowingly tried to coerce and pressure Copeland to testify? And even better, we get this one question from Woody. What's Woody's one concern here? What did we just hear him say?
I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
There you go. So they've got to figure out that stuff with Melnick. I'm going to get it back to real time. Because, you know, what if they just pop up? They're like back in the courtroom, the sound comes back on, and they have an issue they need to handle right away. Nothing would surprise me. Catch that up, get real time. And they're not going to have sound going, but... So back to Army Nurse here, because Army Nurse had said, Kat, if they are starting Copeland's case again and removing his last performance, can the judge remove his immunity signed by the previous judge? Now, what's interesting here? Judge Whitaker is saying, like, look, we want to at least go through the immunity order that you have and make sure it's properly explained to you. We don't explain it with false information. We're not giving you bad advice. This is why we'd also like you to have an attorney here. Although, honestly, I think Judge Whitaker explaining how use immunity works is probably a mile ahead of what the state was doing. Although he should have counsel present if he wishes to have counsel. But if they were to remove the immunity signed by the previous judge, and have to go through that whole ordeal again, will we not end up right back here? Because what would prompt that? He gets back on the stand. He doesn't want to testify. The state wants an immunity order, so they'd have to ask this judge to sign off on one. They want an immunity order for this same witness. Then they need to explain why. And do you think Judge Whitaker, if she doesn't buy into this authority that's apparently out there in the universe somewhere, that we can hold you for as long as it takes us to try all of these co-defendants? Do you think Whitaker is going to advise Copeland, we can hold you longer than these 30 or so weeks that I want to keep this trial going for? Because in my memory, Copeland seemed all right with possibly doing over a year, close to 2 years, to sit this trial out. He didn't want to stay for the other trials, but he seemed to be willing to do a year or two for this trial. 30 weeks is a much smaller ask than 1 to 2 years. So I don't know if the judge is going to necessarily remove his immunity, but Copeland's already presented the idea, the possibility that he's just going to refuse to testify again. And then we have the separate remaining question where he thinks Melnick's possibly representing him still. Melnick may or may not wish to withdraw depending on what Copeland wishes to do. Melnick doesn't seem to believe I can represent Copeland to the best of my ability or properly if he, depending on what he does, because I don't know when I would want to object. I don't know when I would need to step in because he might not be protected from prosecution. So still a lot of moving parts that honestly the judge hasn't gotten answers on. And the only win for the state, I think the only win for the state, is if things remain as they were. And there's absolutely no way that things are going to remain as they were. The state is going to lose something that they're hoping for. I think they're aware of it because just by the body language. I mean, we opened today with Love being concerned about the subpoena for Kenneth Copeland. Copeland walks into court. Like, come on. Yeah, you guys are calling it. And we don't think he's going to testify. Don't think he's going to testify. And yeah, Cheryl. So Cheryl says Judge Whitaker would be able to explain the immunity to Woody far better than any of the attorneys present. And I don't think it would necessarily be right for the defense attorneys to try to explain it, right? He should have his own counsel. But the state, even though they're experienced, they shouldn't be using a misrepresentation of the way things work to tell someone why they should testify. And I really don't think that the judge liked any of that. So Nancy New, thanks for the super chat, says, Woody didn't understand Hylton most of the time. How on earth is he going to understand Love? And I don't know. I don't know if they're going to have Love question him because he apparently won't talk to Love. Can you imagine if they have Love question him? Like, he was already dismissive and did the step back to Hylton. And I don't think he had as much of a gripe at that moment in time as he has overall and currently with Love. Maybe he doesn't like either of them now. And what do you think if a man leads the questioning? You know, the gender can make a difference. Let's just call a spade a spade. Woody could be more aggressive, more hostile towards Atkins because it's another guy. There's no issue of I don't want to hurt her feelings. That could play a role too. I think it would be most interesting to see Atkins do the questioning because I really don't think it would go over well. Love, I think she'll get one-word answers and that's it. So I don't know. Do you guys think Love's going to be the one to lead the questioning? So thank you for your super chat, Nancy. And thank you, K1. Just $1.99 says, great job. I try. Thank you guys for the patience with the sound issue. StreamYard had gave me a message that I lost audio from the shared screen. And I guess you guys, the ones that were watching it in real time, now I know that I have to take down the screen share and then redo it and it fixes itself. So now I know how to fix that next time if it happens again. So sorry about that. And then Garrett S. says, state and judge gave Woody incorrect info and that coercion, 100. So, and that's the thing. They said they did their homework and came up with a solution. but then they still gave incorrect information. Experienced attorneys, they should know better. I feel like even if it doesn't cross the line of malice, the ignorance is inexcusable. And especially to have that conversation with an attorney that was standing in and hadn't seen a copy of the immunity order. I noticed that too. So thanks, Big Tip, for the super chat. How was Woody able to have his phone on the stand? My best answer is it's Woody. It's Kenneth Copeland. And I think the judge didn't mind because, you know, maybe he showed up impromptu and may have been looking at his phone to see if he could hang around later that day. And the judge would rather him try to make sure he can be available later in the day to get this moving. So she didn't want to pick her battle on that. But let's listen. If he comes back today or if he comes back tomorrow, whatever the case is, let's see if she says anything about devices when he comes back into the room. And it's possible maybe a deputy could say something to him too. And then Pierre. So Pierre says, judges fixing state problems and not disciplining their actions. It's not Brady because you have it now. She didn't seem to agree with that yesterday. There was a small conversation back and forth yesterday where Love tried to say that, make that argument. And you could tell she was going to make that argument because of her lines of questions, the way she was asking certain questions to Kayla. But you ended up telling defense attorneys eventually, right? At least one of them. And Love tried to equate what Brady says. Brady wants you to have equal access to Brady material. The defense should have equal access to whatever the state has that fits the criteria of being Brady material. And Love was trying to argue for reasonable access. You know, if you make a reasonable effort, you could obtain the same Brady material that we have access to. In other words, removing the duty to disclose. But that's not what Brady says. With Brady, it's a duty to disclose. So Love tried it, and I don't think that argument landed on Judge Whitaker. She reminded us all that Brady is something that we should all in this courtroom take very seriously. So while I'm waiting to see what she actually does, at least verbally, she did give some pushback against the way Love tried to characterize or take creative licensing with what Brady means. But again, we don't know her having giving pushback in the courtroom. We have to see what actually comes to play when all is said and done. So I hear you. I'm having a little bit more patience, and I don't mind people questioning the judge at all. I've had moments where I'm like, all right, what you're saying would be reasonable if there wasn't all of this context behind it. Because if you're starting from a starting line and you don't know everything behind it, I get why you might think that. But this is a serious case. There's serious charges against people, and all the stuff that happened before here is really relevant. And I think there's been too many occasions where that's been dismissed. All the stuff behind us, we're just looking forward. I don't think it's appropriate or fair to detach from 100 previous days of trial. So I'm not opposed to the criticism at all, but I do think here with Brady, I'm personally interested to see what she ends up deciding or saying. Because I don't know, she seems to really not like that the state played that game. But who knows? And then Kushizuku. Okay, so I know a lot of people here are from the United States and other people are from other countries. If you're from the United States, speak of it as your state. But if you're from another country, let us know what goes on near you. How transparent are your courts? Are there, statewide? In Florida, we're pretty transparent with cameras in the courtroom. A lot of counties have decent public records access. And yeah, we can look back at the transcript. I saw this. Let me pin this. But a lot of other states, there aren't cameras. Cameras aren't required in the courtroom, and judges can just say, nope, not doing this. And then it's really pesky to try to obtain some records. So I am a fan of transparency in the courtrooms. I think that trials should be documented to the best of our abilities. It's not that expensive or cumbersome to set up technology in the courtroom. Get Wi-Fi in the courtroom, get a basic camera, basic audio. I know they're struggling with the mics, but whatever. If we listen hard enough, we can technically hear what's going on, in addition to the transcriptions. Plus, with this case, because it's high profile, Fulton County made the documents a bit more accessible than a regular case. So that's helpful too. But this transparency, I mean, we're getting more transparency in this case than we would in other cases. And we're still like, well, what actually happened? Wait, we don't remember that, but we're able to go and look back. And that's not available for other cases. So huge problem. It drives me nuts, the idea that courts can't be bothered to put a camera in the courtroom. Federal cases aren't really that transparent. That sucks. And maybe federal trials have a bit more seriousness behind them sometimes. So maybe those should be the ones that we get more transparency with, but I agree with you wholeheartedly. Stay Tipsy says, how is that not prosecutorial misconduct by lying to get testimony? Then the judge is trying to fix it. That's crazy. The judge admitted it. So I agree. And I really think this is why they didn't want to disclose the June 7th meeting when everybody had found out about the June 10th meeting. And what was also interesting yesterday, we know that the judge had unsealed records and resealed them, but she said she made a copy of everything. She said she's got folders and folders in her office, her chambers. She's got all these sealed documents. So I wonder if she can go look and see if there's other sealed proceedings. Maybe around June 6th and June 7th. And can you imagine if she were to find out that something else still wasn't disclosed after all this? After she spent a whole day of court yesterday trying to get answers. And then she's to find out that maybe there's another meeting that the state didn't disclose. I think coercion, though, I don't know if she'll think it was intentional or say it was intentional. I think she's going to continue to say that he was improperly advised. And that sounds like misconduct to me. But do you think she'll make a finding that if she finds coercion, she'll say that the prosecutors did it intentionally? That she'll disqualify them? Because that's really the big ask. So thank you so much for the super chat and of course the food for thought. Garrett S says, Tom, Wayne, even Marsha, Brady lives matter. And then we're going to go, let's pull up this transcript. Oh, and actually, let me do it in this view. This is a little bit easier to see. All right, so. And remember, this transcript would be Love's own interpretation. Because that can make a difference. So here, she starts getting right on the first page. She gets into her second concern. This is Love speaking. So she has a concern that I don't know what advice counsel may have offered or may have been offering. That is their right and their business. But you didn't care that he had counsel, but okay. Let me not do flashbacks and revisit this whole transcript with what we know now. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is, which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hylton on Friday that he had never heard of this statute, and we heard him say in court that he knows what use immunity is, but didn't know that this was the statute number, like, directing it. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shart with me and Simone copied, where he said, this is the communication that I received from Miss Love regarding Mr. Copeland. My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which clients are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shart's? He wrote back and said, you're going to get him killed. You have made him, you're making him a target, F you. That is what he wrote in the email. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, his concern has nothing to do with exposure from the state. So Melnick isn't raising a fuss about this testimony because of the state possibly exposing Copeland. We're not the ones that are going to hammer him. And if his concern, his being whose concern, so Judge Glanville's like, who? And Love is like, Mr. Melnick, you know, the attorney we suddenly just found out about. That attorney we didn't know about. If the interest that he is protecting is Mr. Copeland's freedom, meaning not holding him in contempt, which is different than exposure that would get him prosecuted. Love is saying if the interest is protecting Copeland's freedom to not be held in contempt, he didn't convey that by asking us what exposure does he face in testifying. So here I think Miss Love got her intentions confused with what she wanted to say out loud. In fact, if he's concerned that testifying will get Mr. Copeland killed, and he is not communicating with us, he's communicating with counsel for defendants, it would seem that he knows a thing or something that we don't know. So we start this whole issue. He's communicating with all of us through email. I don't know why all 4 of us are named on it. But then it suddenly becomes, he's not communicating with us. He's communicating with counsel for defendants. So he injected himself, but he's also not communicating with us. Like, come on. This is more annoying every time I read it. Oh my gosh. My gosh. Yes. Yes. And I don't like to call everything gaslighting. I think it's an overused term. But boy, do I feel like that when I'm listening to Love make arguments sometimes. Oh my. Oh my goodness. But yeah, it would seem that he knows a thing or something that we don't. But, okay, so we know that Love has been screaming and trying to pull her hair out about reciprocal discovery from the defense that she's not obligated to receive. They're not obligated to turn over. But she's trying to argue that the defense owes them reciprocal discovery. The judge isn't buying into that. We've heard her response orally. And then we're saying it would seem that he knows a thing or something that we don't. But then we also have Hylton later saying that she knows everything about Copeland and knows he didn't do something else, didn't commit another crime. So if you are arguing that you know everything, how are you also so paranoid and arguing that there's something that you don't know and the defense are in cahoots and covering it from you and not disclosing something? Like, this is like one paragraph of like 5 contradictions. Oh my goodness. Additionally, and I will let Miss Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland. So that's her language here reciting this. That's her language. And remember, Kayla has also looked at this transcript. She read a bit of it on her channel. So this is why I think it's very, very good that the judge says, let's just ask Melnick. We know, we did hear yesterday that Melnick, look, if he's going to go up there and continue to plead the 5th, he wants to be discharged. He wants to withdraw. And we know that on June 10th, maybe it was the 11th, I think it was June 10th, we know that Kayla, during a lunch break, went and got the form for herself so she could withdraw, she could be discharged, Copeland could sign off on it. But her situation was different. She was only there to stand in for that ex parte meeting, to deal with the issue of contempt. And once he purged himself by getting back on the stand and continuing to testify, her services were no longer needed. And it was almost like, my read on it, this is my subjective opinion, is if Kenneth Copeland got up and said on a YouTube video that he's still cool with Kayla, it seems like I'm firing her because they're just not letting her leave, right? So that's where I come to the conclusion on that, and why it's only Kayla that Judge Whitaker is aware of any paper being signed, actually being signed. And Love panicked. We watched that clip with Woody. Love panicked. Oh, we think there's one for Melnick too. Well, there may have been a discussion of someone giving them the paper for Melnick to discharge himself. And Melnick at one point seemingly may have wanted to stop representing Woody. But if circumstances change, because either Whitaker is going to appropriately not advise, but make sure this immunity is properly explained to Woody. Woody knows what he's up against as far as contempt. Maybe Melnick's willingness. Maybe he won't feel like this is such a noisy witness situation anymore. Maybe he'd be willing to stand in the court. I can't make that prediction until we know for sure what Woody wants to do and if we see Woody say anything. But this could change the whole course of the game, and there's no winning for the state. There is no way that the state can get a win with this. They don't want Melnick there. They don't want Copeland to be uncooperative. I'm sure they don't like the judge correcting them on their definition of, risks with use immunity. Like, come on. So she goes on to say, if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem that you'd want to be there for him while he's testifying. And then Glanville, with the assist, comes in and says, well, he's on vacation this week. I understand. This is why he has Miss Bumpus here. And he has said what he has said. And I've said what I think he said. Because we know she didn't characterize these emails correctly. So, in a way, this quote of, if Mr. Copeland testifies, we could be getting this quote confused with Melnick saying, if he pleads the fifth. We could be getting this quote mixed up because of telephone game with this transcript of Love's characterization of what Melnick said. And Kayla could be relaying the same thing from recall. So the judge is right. Get Melnick to tell us himself. I don't know if you guys wanted to read any more about the transcript, but that was the relevant part, the part that I was thinking of. And I was also thinking of a hypothetical from Ashley Merchant, which I really wouldn't be surprised if Love had seen this. But back in July, Ashley Merchant had said, the fact that neither the prosecutors or the judge, meaning Judge Glanville, knew what was going on is somewhat terrifying. As soon as a criminal, and this is a hypothetical in general, as soon as a criminal defense lawyer says, if my client testifies, I am withdrawing, anyone who does this work should immediately know that this is a noisy withdrawal. A noisy withdrawal is when, a noisy withdrawal can be more things, like the prosecutor or Linda Johnson in the Rush trial when she withdrew. That's also a noisy withdrawal. But here in this particular situation, a noisy withdrawal is when you believe your client, by testifying, will be potentially committing perjury. It is literally signaled by the words, if he testifies, I'm withdrawing. But Love, apparently in her own legal world, accused the defense lawyer of not protecting his client. She said, whose interest is he, Melnick, protecting by withdrawing if he testifies? His client's or the defendant's? She kept repeating that. She asked for this ex parte because of her concern over whose interest Melnick was protecting by withdrawing. Love told the court that Melnick was withdrawing if Copeland testified. Immediately, the court and counsel should have known what that meant. Melnick was doing his ethical and legal duty by threatening to withdraw if Copeland testified. Court and counsel should have immediately figured this out, but instead, Love kept accusing Melnick of having conflicted loyalties. So, little flashback there, you guys, from Ashley Merchant. And we'll get the court screen back up. I know, we actually have a ways to go. Because I said 1:30. But still, just in case. And yeah, so Kedrick here says, intentional or not, they coerced him. The judge said it. They are professionals and should have to pay for their actions. And these are professionals that are teaching courses. They are the mentors for the next line of people that could enter into some, maybe they won't become prosecutors. I think they're just doing legal education law courses. But people entering the field in general, whether they become prosecutors or criminal defense attorneys, these are the people educating this next generation. So if they're in that role and they're educating people, they shouldn't be ignorant to the things that they're supposed to be teaching. They're experienced and they play the position of a teacher. And they're getting this wrong. So it's either gross incompetence, or it was intentional coercion because they just wanted to compel this witness to testify. And neither of those are good. Miss Kim, thank you for the super chat. Kat, you should consider law school. You are the truth. But I stumble over my words. I'm really bad at arguing. I like to talk and think. I'm so bad at arguing. I would never want to be like in the position where I have to go up on a whim and improv at the podium and make my argument against someone else. I just don't think I'd be very good at it. But it's so sweet of you to, you know, with the encouragement. I do want to keep learning just because. So Stay Tipsy says, remember in the beginning, Miss Love coerced the judge by giving false information about how long he can sit in jail for. Then the judge relayed it. Yeah, so we just looked at that part of like proceeding, like leading up to that part. We can pull that back up. Let me search it and I'll pull the transcript back up. Okay, I don't know why it took me so long to find this page, but here we go. So looking back at because I think I wanted to see, and it looks like this may have been Hylton. Which is still, guys, to me, it doesn't really make that much of a difference if it was Hylton or Love because they're on the same, they're both the state. Yeah, so Kayla's trying to walk through it. There we go. Okay, so this is where it starts. So from Hylton, they're trying to figure out, and then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came and then we had court. And Kayla says, so you're pretty much saying you didn't ask for this? Woody says, I didn't. And Hylton says, but we gave it. He doesn't have to ask for it. Kayla says, I know. I mean, he's just saying, Hylton, right. He doesn't have to ask for it, but to alleviate whatever his concerns were. Whatever. We gave him immunity. So we don't care what your concerns were because we know what we want out of you. He didn't have to ask for it. Miss Bumpus. So if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking it through. Miss Hylton, Miss Bumpus, would he still have to have had to testify, or would he have been able to plead the fifth? That's what he's saying. Hylton, if he did not have immunity? Kayla, yes. Hylton, yes, he could plead the fifth. Copeland, that's what I'm... And then Bumpus, that's what he's trying to say. He's trying to say he didn't ask for this. Hylton, but he doesn't have to ask for it. Now that we've given it to him, because that's on us. So now that we've given it to him, it's an order. He can still choose if this is the road he wants to take, then he'll just stay in custody until the trial's over. And when we say the trial's over, every last defendant has been tried. Not just these 6, the other ones too. Copeland, I done longer time. Miss Hylton, all right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record the state does not want you in custody. What the state would like you to do is purge yourself from... What purge yourself mean? Meaning that you are no longer in custody. And the way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way. But we don't want you in custody. The only thing that's holding you is refusing to testify. Judge Glanville. So do you have any questions? Any other questions? Basically, if you invoke the fifth, Copeland, I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor. And we heard, I think Copeland said himself that he was referring to Kayla. Miss Hylton, this is your insurance. I don't know if you want to break that down to him. Miss Bumpus, well, he doesn't want that. Judge Glanville, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is that They said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made, from the state's perspective, they have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference. And then in this particular scenario, they've taken that away. You can still invoke your Fifth Amendment privilege. You can still do that. But the consequence of invoking is you will just remain in custody. If you testify, you get out of custody, and you stay out of custody until you're done. And then Copeland asks again. And then if I don't testify, I have to stay until when? Until the trial's over, until all the defendants have been. I've got these 6 that we have right now, and then there's another 6. Hylton says no, there's another 12. Judge Glanville, there's another 12 or thereabouts that are still outstanding in various forms or another. And then Copeland wants to speak with Kayla. So revisiting all of that, definitely remember that in the beginning. And I do want to clarify that I'm sure Love is on the same page, but this conversation right here in the transcript was between Hylton. Love wasn't in the room anymore. Love is on the same page anyway. They're operating on the same team. But still, like, this is it. This is that thing. They apparently did their homework to see if they could find a way to convince him to testify. And Whitaker's challenging them today. Like, I don't think that that's right. Your subpoena is for this case, not for the cases for the other co-defendants. It's great. Thank you so much, Stay Tipsy. It's great to revisit that transcript now. Patrick Taylor, why does Love sound like every arc is not hers and can be written be written by chat AI law system? Well, I think it was it the hood lawyer? I think the hood lawyer on X clipped the screenshot. Or he like took his phone out and was recording. I think he was projecting the trial stream on his wall. And he took his phone out and recorded and zoomed in on Love's screen, and it was on that AI legal website. So, Patrick Taylor, to answer your question, thanks for the $9.99. It might sound like a chat AI law system because she was using that. She had it open. So, there you go. Nick Starro, thanks so much for the Corona. Kat already knows I'm sniping over lunch. And no, that's okay. You're always welcome to stream snipe. Or like use the water guns because, you know, we got to keep it PG for YouTube. So snipe away. We're raving to you over here. And then Nancy, great point. So Nancy News says, Melnick couldn't put his bar card on the line with Woody testifying, knowing he would lie. That's why he advised him to plead the Fifth. And I think we're really going to get major clarification on this from Melnick today if he's able to come in. I want to see somebody, and it might be Whitaker if the defense doesn't get the question first. But imagine if it's Judge Whitaker herself that asks Woody, you know, back in June, when you were meeting with Miss Hylton one-on-one, did she ever ask you if you had an attorney? Did you tell her you didn't have an attorney? And I'm not going to lie, it could be possible that he really did tell Hylton that he didn't have an attorney. And I still don't know why they would have already been in a point where they're having a conversation with him before they looked at the records and tried to reach out to Mr. Melnick first to see. So Copeland saying that doesn't exonerate the state from not trying to see if he had counsel first. Because they were already meeting with him one-on-one before they made the inquiry that they could have made through the court records. But at the same time, I wouldn't be surprised if we find out that Woody was using that to play Hylton. And Hylton thought we were building great rapport or whatever she said. So I definitely think Melnick is trying to do the right things. Attorneys have a duty of candor to the tribunal. They're not supposed to put someone that they know is going to lie on the stand. And sometimes that can be tricky, right? You don't want to get into attorney privilege or conversations you had with your client to let the judge know why you feel like you need to withdraw. But a judge should understand, especially a chief judge like Glanville, someone with experience and a standing, should understand what it means when an attorney says they want to withdraw, but can't really give you the exact reason because it would divulge, it would include divulging attorney-client privilege information. So I don't know. Definitely not worth risking a bar card just to, honestly put your client at risk. Because that's the flip side, right? If it would be unethical, it could be something that also would convey risk to your client. So all of this fuss from the state about he's not looking out for his client's best interests. Well, if he's saying I can't properly represent him because I don't know the context of it if he's planning to do this on the stand, his concern seems to be I can't represent him well, which seems to be in the interest also of the client. So Nancy New, you're on point. FFS says, love really doesn't Woody want Woody to have the benefit of having an attorney while he's on the stand, which I really don't think he will even testify. He had me dying laughing right from the start. Yeah, and I think it's going to be that same thing all over. We just tried to go through all these evidentiary issues relating to the jail calls for Copeland. Today we've been talking about Zachary's statements, but a little bit yesterday and then last week, we're going through all these, June 10th from 2015, all these calls. What can come in? Just possibly for Woody to get up there and just, I don't recall, not lay any foundation. And we're going to, even though we're rewinding some of it, the state's going to be stuck. I don't think Woody's going to give them anything to lay the foundation that Whitaker's going to look for. And then Kedrick, do you think she's enjoying the tension, kind of like Glanville? Why hasn't she ruled on the mistrial yet? I think she's actually considering them. She even specified earlier today, and maybe I'm getting my days mixed up. Maybe it was at the end of the day yesterday. But she's already written a response to some of the arguments. But she's still looking at a few of the arguments. And she pointed out to Love that her oral response today this morning didn't address some of the outstanding arguments. So I think she hasn't ruled because she's waiting to write on a few arguments. She's looking at if there was a Brady issue. She's looking at, was this a critical stage of the proceedings? And if rightfully the defense objects to rewinding completely and starting over with Woody. And we have to keep this immunity in place. We don't redo any meeting about the immunity order. That means we can't redo something that was probably a critical stage. I think she's considering legally that was a critical stage of the trial because he was sworn in. If the defense gives a valid argument as to why we can't rewind all the way and redo all of that, then there's going to be a frozen part of the trial that was a critical stage that the defense was excluded from. And the state has not countered that argument. They touched on it in an earlier motion with like a paragraph and a half, but they didn't touch on it with the renewed motions from Shard and the oral arguments from Shard. We'll see if they do on Friday with their response. But I think she hasn't ruled on it because of those two arguments that I don't think the state knows how to address. I don't think there's case law because I think they were wrong. So I'm excited to see the response. You guys mark your calendars for Friday. We will definitely read that response. It might be late if the state files it last minute. We might be doing that at like 6 p.m., 7 p.m. on Friday. And well, Nick Starr's probably doing a panel, so maybe that'll coincide with the right time. So we'll play that by ear, but we definitely need to look at that. And then Nara Alexis, thanks so much for the super chat. And then thanks for becoming a member, FFS. And then Nick Starro, so Carr v. State, regarding mid-trial Brady. Yeah, let's look that up. Ugh, I hate that it doesn't let me copy and paste. Sometimes it does, sometimes it doesn't. Let me just type that. Okay, we've got like 20 minutes, so. And how long is this? So let's bumper this. We'll look at the first, because sometimes they'll give you a brief right at the beginning and then right at the end. So Supreme Court of Georgia, this appeal is from Weldon. This appeal is from Weldon Wayne Carr's conviction of malice murder and first-degree arson. Carr's wife died in a fire in their home. He recounted to authorities that he awoke and realized there was a fire downstairs in their home, that he tried to get his wife to escape with him through a bedroom window, but she resisted and tried to go towards the fire, and that he lost her in the smoke and confusion after a struggle, but finally saved himself by jumping out of a second-story window. The state's theory of the case was that Carr set the fire, then injured his wife so that she could not escape. Although she died of smoke inhalation, Carr's wife suffered other injuries, including cerebral bleeding, and prior to the fire, the couple had been experiencing marital difficulty and had been seeing a marriage counselor. Miss Carr was having an affair of which Carr had learned, and she had told several persons that she intended to divorce Carr and marry her lover. In a short period before the fire, Carr engaged in conduct which appeared suspicious after the fire, checking on fire insurance, getting copies of his and his wife's will, telling their adult son, who resided elsewhere, to remove some of his belongings from the family home, putting valuables into a safe deposit box, and conducting an uncharacteristic spring cleaning of the house. To support its theory that Carr used an accelerant to start the fire, the state presented evidence that burn patterns at the site of the fire's origin were consistent with the use of an accelerant, and presented testimony that a dog trained to indicate the presence of chemical accelerants had alerted at the same site. So, that sounds pretty, like the dots all line up, right? On appeal, Carr contends the trial court erred in the following ways: permitting evidence of a dog alerting to the possible presence of an accelerant as substantive evidence of the presence of an accelerant, ordering certain pretrial discovery, admitting into evidence inadmissible hearsay testimony, improperly admitting bad character evidence, excluding defense evidence regarding the reliability of a dog alert evidence, erroneously qualifying witnesses as experts, permitting testimony tainted by a warrantless search, refusing to record the entire proceeding, and improperly limiting the evidence presented on motion for a new trial. He also contends his convictions must be reversed because of prosecutorial misconduct, and because the evidence presented at trial was insufficient to support the convictions. After a review of the voluminous record and the extensive argument of counsel, we conclude that the convictions must be reversed for the reasons as follows. Now I'm going to see if we get, because there's a few arguments here. Was it late disclosure? Let me see. Oh, I'm in the search bar for the window. Wrong thing. So let's see. Maybe this is the argument relating. So in accordance with Sable v. State, the trial court ordered the defense to disclose to the prosecution the results of all scientific tests and experiments conducted by the defense. Carr complains the order had a chilling effect on the development of his defense, and that he forewent certain testing because he could not be sure in advance that the test results would be positive for him. In Rower v. State, this court overruled Sable to the extent that it gives the state any discovery rights greater than those specifically granted to defendants by OCGA 17.7-11. Although the Sable order in the present case was correct when it was entered, Rower was decided just before the trial began. Thus, this case was in the pipeline. The Rower rule applies, and this was an error. And that's Childress v. State. The state concedes that the order was erroneous under Rower, but contends that any error was harmless. Because we find it necessary to reverse the convictions in this case for the reasons stated in Division 1, and because the tests were conducted after the trial, and Carr will have the use of them for a retrial if there is one, we need not decide whether the error ordering full disclosure of the results of all tests and experiments conducted by the defense was harmful. Do we get a misconduct one? It's long, so I just want to get to the... Oh my gosh, this is a long... This is a long paragraph, Nick. This one's long. This is long. I think this will cut us into the trial. So I'm going to paste this in here. This is what we're looking at. And then do want to make sure we're back up over here. So I do love some case law, but I might want to read that in full. But yeah, that's interesting because it's Georgia. That's right from Georgia. So, it's not like we've seen some other case law come in where it's like, in Ohio, they said this one time, and it might be pending an appeal, but right now it still stands. And then FFS says the foundation to uphold this is being broken down harder than the heels on Love's salamander pink shoes. Those were like salamander pink, salmon pink. I have a notepad here. They're kind of like this color. Oh, that was so funny. So we have the ice cream cone. It could be like a drumstick. Like how the drumstick puts like a little bit of the chocolate in the bottom of the ice cream cone, but it can be strawberry if we put the shoes in too. It was a Cash Money Cass had said earlier that her outfit looked like a strawberry cone. Thank you so much, FFS. Ray LF says, I would love to know why Miss Love is so adverse to Melnick being involved. I mean, there could be personal animosity there, but the number one reason to me would just be that Melnick was making an argument that his testimony shouldn't be forced if he wants to plead the fifth. Oh, we'll just give him immunity to get around that. We'll pretend we're not going to reach out to his attorney. We're just going to explain this to him ourselves. We're going to explain to Woody how this immunity works, and we're going to explain it wrong because Woody's giving us some skepticism. Because remember, Hylton was trying to explain it to him at length before the June 7th ex parte. They've been trying to explain it their way. However they wanted to represent what this immunity order actually meant to Woody. And Melnick says, I would never have agreed to an immunity order like this. There's problems. Judge Whitaker is like, yeah, the way you're explaining it to him is problematic. So I think the reason Love is so scared is because Melnick trying to do his job is an obstacle to the result that she wants. And I think it's interesting that Adam Abadi has, he had a gripe too a little bit, but I think maybe that's like a personal long-standing issue. But I think Love just wanted her way with this witness. This is her way of dealing with difficult witnesses. That's supposed to be her specialty. And Melnick wasn't having it. And Baby Girl, thanks so much for the super chat. This is a great point. Guys, how do you feel about Shard now that Glanville's gone? Because when Shard used to try to get up and raise objections or make an argument, Glanville was always like beating down on him verbally. And we can kind of see why, last Friday, if you looked at Shard's motion, he discusses very early in the trial, Glanville accused him of making a curse word statement about Glanville. Glanville demanded to know or have him admit that he said it and that he had cameras and he knows that he said it because there's cameras that can prove it. And Max Sharp was like, what are you talking about? I didn't say that. You're asking me to lie to you. And I can see, like, this whole time, Glanville has really been hot-headed when it comes to Brian Steele and Max Sharp. And now we kind of understand there's some background as to why he's doing that with Shard. And now when Shard gets up to make arguments, he actually gets to speak. And yesterday we saw Whitaker actually leaning in to listen to him about that critical stage argument. That my clients and the other defendants in this room were denied the opportunity to be present during a critical stage of the trial. So not only was the judge not interrupting him and yelling at him, she was actually listening. So great comment there. Shout out to Max Shart. And then FFS says, found you from AV7. I love AV, guys. So when my stream ended yesterday, I saw AV was still live. And I went in there, I swear I was commenting like, oh my God, I'm so happy to be in the chat. And as I was typing it, she's like, bye-bye. And I was like, no. So the chat like ended. And then luckily like an hour later, she ends up going live with TLA. So it was fine. But at first I was like, oh man. Thought I could hang out in there. And then it was just like the rug was ripped out from under my feet in the same seconds. So glad that you're here. Love the community over there as well. So you know how that goes. It's so awesome to be able to meet new people in different chats and see familiar faces through YouTube. Tina Haskenhoff says, I think Love, with some friendly advice from Glanville, distanced herself from the start and allowed someone else to do the dirty work. Love is probably not even loyal to her own grandchildren. Oh, does she have kids? Does Glanville have kids, you guys? I didn't know that. I didn't really look into the background, but is she a grandma? And hold on, do we have Kayla in the chat? I'm seeing people mention Kayla. Let me scroll my butt. And Tina, I agree. I think, I don't know, part of me is like, well, maybe Woody really wasn't going to talk to Love anyway, so she had to have Hylton do it. But some of the arguments Love was making yesterday were about clearing her own name. Like going after Kayla for the statement about, was it the covering the ears? And was that Hylton that said it, or was it Love that said it? Love was so focused on clearing up a misconception about her, possibly. Okay, and I just see Kayla. Okay. So hey, Kayla, I think I'm jumping into a random conversation because Kayla's saying, yes, his son was my intern when I was DA. So maybe we're talking about Glanville. I don't know for sure, but I'm just going to piece these two together. And hold on, Kayla, let me know if you want a link right before we get back up on the stream. When I clicked the invite button last time, that's what froze out that screen share audio. So Rachel, you saw the same thing. Rachel says, Kat, I went right to AV2 and saw your comment and then the stream ended. I was literally like that meme with the Pepe frog where he's like happy and then he just gets like really sad. Michael Sanchez, good to see you. Yeah, so again, guys, I mean, that was probably like the punch moment of the day. And let me get, okay, so Kayla just popped in, but it says device is not connected. So let me figure out, let her figure out what's going on there. But I think that was a big moment, was him just saying, well, how long? That's just this trial? Kayla, you're a white screen. I'm going to add you to the stage. All right, we've got the loading circle for you. All right, we lost her. Yeah, so Kanisha, I really think he can say that. And Judge Whitaker is like, I don't know how much we can trust what Copeland says. But at the same time, if he's the only one that can speak to feeling coerced or not, and he were to say, yeah, they tried to force me to testify, and I didn't want to, and I didn't really trust what they were saying. The transcript alludes to him not trusting what they were saying. He says it flat out. Okay, so Kayla just popped back in. But yeah, I think if he says it, it's still testimony that he felt coerced, whether the judge finds it credible or not. The standard's really only preponderance. Or maybe Kayla can correct me on that. Okay, I see you this time. I see a video this time, Kayla. It says you're muted, though.
Okay.
Yeah, you're on the plane. Are you on the plane? So let us know. People are still confused about your clarification on the transcript. And I think you can clear the air. To me, I interpreted it as you saying the transcript doesn't contain everything because things happened off the record. So you're not going to get the full context if you look at the transcript. You're going to be missing pieces from things that the state was present for, conversations the state was present for. So disclosing that transcript doesn't mean that everything the state is aware of, Brady evidence, was actually disclosed just because you turned over the transcript. And I think
Yeah,
that's what you
so
meant.
yeah, that was my point. My point was, as far as what was on the record, it was complete, but there were off the record conversations that made the defense not have everything that happened in the meeting. But as far as on the record, the transcript is complete. But I said from the beginning there were off the record conversations.
Yep, that's what I took from it. I get why Whitaker wanted to be granular and like completely clarify it. But I think people took that as you giving a misrepresentation about the transcript. And I don't really think that's the case, because I remembered a live where you said, I have to see the transcript first because not all of it was taken down. So I have to see what was actually taken down. So, and then any thoughts on Woody today and Melnick, the confusion about Melnick being his attorney and whether Melnick wants to continue to represent him?
I guess, I don't know. I'm just wondering, have they got him on the phone?
Not before lunch, but I think if they do over lunch, it'll
I-
probably be the first thing mentioned.
Yeah, that's what I'm excited to see. I don't know. I'll just say I don't know. I can't speak on that right now.
Sounds good. Understood. And then where are you going? Well, you don't have to tell us where you're going, but if you want to, if you want to tell us where you're going.
I'm supposed to be going to Brazil, but the flight was oversold really bad, so we ended up going to St. Lucia.
Sounds like the same thing to me. So, sounds like out of the country.
Yeah,
I think you'll have
but
a good
I guess
time.
I'll talk to you guys. I'll be landing shortly. Okay, I'm still
Alrighty,
in the
well,
chat.
we'll get back up. Court's about to start in 3 minutes. Thanks so much for the clarification. There you go, you guys. So, doesn't know for 100%, but is excited to see what happens with Melnick and what Woody wants to do with his testimony. Yeah, everybody wants to go on vacation. But there you go. Do you guys think that makes sense about the transcript? And what was missing and what wasn't included in the transcript and why it wasn't included? Because that was the number one thing I saw confusion about was yesterday. Was, oh, I thought there was stuff missing from the transcript, but now we find out there's nothing missing from the transcript. Technically, not everything was captured by the transcript, but it was expected that some stuff wouldn't be captured. But the state was still aware of things that were said in these off-the-record moments that they should have disclosed to the defense. And that's a huge win for the defense. To get testimony, and it was confirmed by Detective Long. He tried not to confirm it, in my opinion, but he ended up having to. That there was substantive matters talked about off the record that the defense never had disclosure for. That was a huge, huge win for the state. And I think we got caught up in the nerves and the flash and bang of everything going on in the courtroom. But really, that was the takeaway I got from all of that yesterday. There was major Brady material, major possibility that Brady material was still to this day not disclosed properly to the defense. There you go. That's exactly it, praying Grammy Pammy. Brady is Brady, off record or on. Hold on. We're not fleeing the country. There you go. And then April had said, what are your thoughts on Judge Glanville still being a judge when Judge Peterson was removed for having an ex parte? Well, my thoughts there are this is the process and this is how long it takes, because with Christina Peterson, I think they were looking as early as 2021. And the Judicial Qualifications Commission was like putting their report together for like a year and a half and then trying to present it for another year. They finally present it. And then the Supreme Court had to make their considerations based on that report, which took them several more months after that. So really that timeline started back 3 years ago for us to where we got, was that June that it was announced that Judge Christina Peterson was removed from the bench, it took like 3 years. So I have thoughts in general that I think it's a slow process. So thanks for your super chat, but it doesn't mean that this is the end. It just might be a few years that something happens.
We got everybody? All right.
So thank you, April.
All right, what I know about Mr. Melnick at this point is that he is going to be available by Zoom.
All right.
3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation.
So an hour and a half, we'll find out.
All right. Yes. Am I cold? Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up 0.5 degree for y'all. And then if y'all, okay. Now, there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay. All right, so we were, I think, on item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment, which was to look up the law and to look up what we should tell Ms. Copeland. I don't have.
oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have a copy.
That's fine. It'll just take me a second to get it pulled up.
I thought she was about to pull a copy. I was going to be so surprised she had one ready.
So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute,
And then in the meantime, so JC says that Kayla's lying. She was adamant about the transcript not being complete. She mentioned it on multiple streams along with Liddy. She just got caught up in trying to retract exactly what she meant. See, I take a different stance.
just the plain language of the
I'm going to come back to
statute,
it.
Your Honor, which is essentially a statute, not saying that the court can grant immunity, but that the state can grant it, and we have to move the court. It lays out very specific steps that we have to take.
Hang on a second. Can you not hear her? All right, can you, I don't know, do those mics move?
It wasn't on.
Okay.
It wasn't on.
There we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need,
Not buying it.
if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I
okay.
haven't fully got it. It's in re-long.
So you didn't have it
Georgia App 306
on June
reading it.
10th.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
And in And it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
It is for a different proposition. I haven't read it myself either, but.
Like, where was this on June 10th? They said they did their homework and then we still don't
I don't
actually
know
have a
that
case that
this-
backs them up.
Case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is, I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point, however, it would make logical sense that it couldn't go past the end of the trial, because how would Mr. Copeland purge himself of contempt at the interim time between two trials?
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
Right.
That was less, yeah.
so I'm sort of going with through the end of this trial unless somebody tells me differently.
You think Atkins can find something quick?
All right, has anybody come up with anything else that he ought to be advised about?
This is important because they need to know this for the Melnick conversation.
Your Honor, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified the last time, Judge Glanville, I think, gave him a
Gave
copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh, in court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made.
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
And then JC, I think you mentioned you're going to look at the old live.
So I'm seeing if a half degree will make a difference.
I will survive.
Do you think the retraction yesterday made a difference?
Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03 and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hylton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hylton were trying to make sure he understood. But Ms. Hylton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but, you know, I mean, yeah, there'd have to be some, you know, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, you know, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hylton out there in the foyer area.
Yeah, and then, you know, we also discussed the like immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. Right. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely to the extent we can correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions because, for instance, I even heard, it may have just been a misstatement. Obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, you know, that was in there from the start. And
all right. And yeah, do you want to, I mean, I can, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
and I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists. Like if he would speak to us, but he,
Well, maybe we
Can
can
you-
dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not, who knew what when and who was professional and who wasn't. And maybe we can, I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
you're beyond it. Great. We'll see if he is.
And I would endeavor, I would love to be able to fully explain, to allay any fears that he has or concerns about his
Sure.
client's criminal exposure, but 161070 is the perjury.
Okay.
statute.
And then I ought to know prior and consistent statements by heart, but which one is that? 24 something? I don't know. I'm sure I have it in front of me somewhere, but I think those would be the four relevant things: the order 507, perjury statute, and prior and consistent statements.
Miss AB, you are 100% right. Could just have an attorney,
Whatever,
but they
I'll
didn't want
figure
him
it
to
out
have
later. I can
one
find
back in
prior and
June.
Consistent statements.
246630. Wait. Twenty-four, 6, 6, 13.
And now it's Melnick's fault. He doesn't want to talk to us.
24, 6, 6, 13B.
So Ms. Pressfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that. Yes. Yes, I don't, who said that?
On that side.
You did what? Say that again.
Email.
Ah, okay, to Ms. Pressfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited in the footnote 1, from the Middle District of Tennessee, our issue is a deposition, the person refused to testify, there were trials coming up, they were not set yet. The government's position is like the state of Georgia.
Government's position is like the state of Georgia here, just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And then the footnote they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against a person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, really, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
There we go.
Which can't be the law.
And Judge,
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure, did you send it to everybody?
He did. I got
Okay,
it.
yeah.
I just want to read it.
and Judge,
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of Banks. In re estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under
There you go.
civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact
Put a
case you
CM in the
needed.
chat for
So
Carrington
that
Matthews.
answers the question
CM.
for me. You can look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right, so.
Yeah, Carrington Matthews. Steele did his thing too.
So I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hylton had said there are certain things that even. Okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hylton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hylton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying about that.
And, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, sort of when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And
He
then
bullet
maybe
pointed
give
what they
him,
had wrong.
assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I inquired the court regarding the court's earlier statements about the case that Mr. Matthew cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be you've said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that is my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and
Thank
I get
you.
it, but I don't
Thank you.
think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean to this part of it. Okay.
Oh my.
All right. So
Thank you, Miss AB. I agree.
let's go back to our
Like, finally, she just said, I'm done listening to love. Make
narrowing
these
down,
anything that sticks arguments.
figuring out what needs to be redacted out from these statements of Mr. Zachary.
Your Honor, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I mean, I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a layperson, Mr. Whittiers, navigate his way through these things. So I would agree with the court's inclination.
Okay. And if for whatever reason, a public defender or conflict defender cannot represent a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, then, but if they can't for whatever reason, then I don't know, we just have to.
Then I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested in Mr. Copeland's testimony than either side, and so I think it would be the court's responsibility at that time.
What's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
good.
All right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here.
So shout out to Angela Hornsby for becoming a new member and for the $1 super chat. JC, I saw that you sent over a clip. Let me get it over from my phone. So I'm not forgetting you, but I also pulled up. I saw that after my question, you'd sent another chat. I'd start it so I wouldn't lose it. That yes, that she had no choice but to clean up her mess. But I think ultimately, whether or not she did a great job explaining what she meant by what was on the record or not, and we can look at the clip you sent, I still think at the end of the day, the whole purpose of it was there was more that would have been Brady material that Hylton was aware of. Because I believe all those off-the-record moments involved Hylton, not Love. But that Hylton would have been aware of, that weren't disclosed. And personally, I think the defense got what they wanted out of it. So we can look at the clip. I'm going to pull it over. I don't know if this quick bathroom break will be expeditious or long. It'll be a Glanville break or a Whitaker break. But on the flip side here, Torres says, Kayla mentioned off the record conversations when she did her live covering the transcript. I don't think she knew the magnitude of the conversation. And where I'm going back to, JC, is the idea that she was caught up. I think she may have been caught up, but I don't think it was malicious. And maybe you think it was malicious. Maybe you think it was intentional. And I'm fine with disagreement because, I don't know everything all the time. Like, I'm normal. I'm a human. But if she was in that room trying to figure out what was going on and all these people are moving in and out of the room, I don't know if I would have a complete recollection, even a week after, of everything that happened in that moment. I mean, there's things that when I'm watching a stream, I miss certain things that are said because I'm starting to look at something that's happening on the screen and I stop listening so much. Or I miss something that is happening in the courtroom because I'm listening and not looking. So I think she suspected that stuff wasn't included, didn't know if it was necessarily something that should have been transcribed or not. And that's really where I put myself. And I think at the end of the day, we found out that the state withheld Brady information and that the transcript can't cure that. But I hear you. There was a lot of people that expected that there would be some, enlightenment that Glanville or the court reporter took a page of the transcript and just redacted all of it, cut it out, didn't want anyone to know it was redacted, and that Kayla was going to come in there and tell us, like, no, right here, there should have been 5 more lines, like 2 more statements back and forth that were completely removed from this transcript. And I never had that expectation personally. And I know today we have a lot more people watching than may have watched me a week, 2 weeks ago, which is awesome. Thanks so much, you guys. But, back when it was just like a couple dozen of us talking about it, we're like, I personally didn't think that significant things were cut out of the transcript. I just think that certain things may not have been recorded, which is a separate terminology. And I really think our disagreement is over our characterization of saying something should be in the transcript and what our definition of should be in the transcript means. So we can look at that clip when we get some more time. And thank you. I love having this is kind of the conversation I like to see back and forth. We have, well, maybe this, and then maybe this. And then Miss AB had said earlier, this was about 15 minutes ago, but Miss AB said to me, it goes to show that they were trying to use Woody only to get those old police video interviews into evidence. No one remembers as much details as expressed in those interviews. They built their case around those videos. And we can see the panic in that possibly falling apart. Judge Whitaker is saying, okay, yeah, derivative use. He shouldn't be prosecuted for anything that derives from his testimony here in this case. That's good for Woody. It may or may not be good for the defense. It may or may not be good for the state. It may or may not change the way Woody gets up there and testifies. But we have these other 2 major L's. I mean, Whitaker bullet pointed out again, that we have to clarify what perjury means, what it means to give a false statement, what it means when you say you would intend to charge him with perjury for one thing, but not intend to charge him for another thing that might also be perjury, but maybe not as big. So Judge Whitaker is saying you guys are still misrepresenting all of this. And then we just watched her continue to argue for 15 minutes about the difference between holding him for maybe 30 weeks to a year, whatever, versus holding him longer because of the other co-defendants. It's insane. It's exactly what you're pointing out. Because otherwise, why would it matter? Why would you also want to be able to hold him for longer? You need to force him to testify in this trial. And you're looking to stretch the law, reinterpret the law to be able to do it, because your whole case rests on what you need to introduce through him. And that's only assuming we move this trial forward, Woody gets on the stand, he doesn't refuse to testify, he starts to testify, But then the state has this other obstacle of actually laying the proper foundation to Judge Whitaker's standards. Do you think that that will happen? So thank you so much, Miss AB. And again, he did not ask for that immunity. And thank you so much, Garrett. Guys, Love's middle name is now Extrapolate. Yeah, Woody's gonna come back and give us more merch printable t-shirts. I saw someone say that he has a merch line now with stuff from the trial.
In terms of our potential redaction and reporting.
Okay, so it looks like until 3 o'clock with Melnick doing the Zoom, we'll be looking back at Zachary Redactions to Zachary Statements.
Should I take silence as a sin?
How about resignation? Because,
Yeah. Fair enough. All right. So, and whenever Mr. Melnick joins us, we'll just take a pause and let some deal with that. All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I've uploaded, I've neglected to inform the court, I uploaded that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, sure.
Okay.
I try to keep the same link for the transcript, so I will resend you that link. And then there's one long version of the video, and there's a smaller one where it breaks it into smaller chunks. I've used VLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
Okay. I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me.
I recommend that you send smaller chunks, because bigger chunks have a harder time.
Actually sending, yeah. All right. And is this hearsay?
So, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70, where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day. Zachary says that's when their spot got shot up. That was the next day, though. You're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Moochie's mama's house got shot up, and Zachary says, yeah, and Dennis says, right, and Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing a proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased. But, oh, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or down through more, it looks like.
Well, then they
through
start
78 line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21. That's page 79, line 14 through 22. Speculation about who shot at Thug's stepdad's house. Hang on, 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, I mean, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list. The latter, page 79, 23 through 24. I have no objection to page 80, the entirety of page 80. What do we want to do? And up through page 80.
They're saying 81 line 5. Let's deal with that. I mean, that all looks like.
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When Investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
Is that supposed to say?
I can go without that. So
All right,
1
so-
through 5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81 line 13 through 82 line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. My problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through Investigator Dennis sharing information with Mr. Zachary.
Yeah, okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those videos with you.
All right.
So I was.
That's okay. So we're talking about 81 line 13 through 82 line 3 and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23?
No, yeah, through 82 line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83 line 18 through 84 line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88 lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement, it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, and my client went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting, so.
Well, people in Cobb County would be interested in that, but.
Okay, well, I don't know. I mean, maybe they're just saying that to see what he's going to say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time. Okay, do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you would literally have to have one hand on the wheel, and it was a precarious kind of.
He just closed the laptop.
Would, be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay, and I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have.
So is Mr. Zachary in a second car that's involved in this?
So he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
compound.
right.
Everybody shows up at this one place where Wayne is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour bus.
Okay. But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
Yes, he
Okay.
says, Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting he can't Shannon, if he's crossed on that, I would argue that goes, it's way not as admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary, it sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that, what's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay,
Because I don't have, there's never been a time where I heard him say, you know.
okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about,
So, but 5.
how about that? I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them. Well, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at,
This is painful.
the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's on, not here, on the Zoom, virtually here. Do y'all all have the Zoom link?
All right,
I
might
mean,
be
you're
Melnick
welcome
time.
to- I see that'll show up on, does it show up on that big screen? All right.
I hope they zoom
so
us in.
Y'all can just watch it on the big screen.
Are you ready for him?
I am. I think, I say yes, and yet I think I need to probably turn my camera on. There we go.
Thank you so much, Joel, for becoming a member.
Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Predictions, lawyer or no?
So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay.
Oh,
All right. So, and you're representing him that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person? If we can have him here in person, that way, if he does have questions as anything's going along, and we're not going to take testimony. I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He could be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And
Here we
Honor,
go.
before he's brought in,
Yeah.
I would object to him being asked at this, I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just here.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
When do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed.
Okay. All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So
Oh my God, this camera.
If that's your objection,
It was just the timing of it.
so would you rather I do it Friday? I mean, what, I don't understand what it is you want me to do.
It was
Delay.
preference, but I'm gonna, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place, I'm just make certain that the interests of everybody are protected.
Okay.
Who's?
I-
I'm not trying to create a.
No,
Who's
I
everybody?
understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay, so Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay.
Melnick
All
says,
right.
let's go.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed
Okay.
it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway, it's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay.
He understands.
All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay, is there a screen where he can actually see Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr.
Bring in
Copeland
Moody.
in.
And then thank you, Garrett. Yeah, you guys noticing a lack of hand signs? And then Miss AV, perfect comment for this time. I'm telling y'all, the state, don't want Copeland. They only want those videos. Their case is falling apart. And Whitaker said no court on Friday. She's got this appointment. So how do you delay it? Whitaker says, let's do it now.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say, you know,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied
I
and lied and
know, I
lied.
know. And,
So how is they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So.
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
Not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Oh my gosh.
Yeah, yes, and then I'll see whether that's what I think or not, yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Wow.
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. You know, if you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now,
This is crazy.
if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
This is crazy.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now.
She certainly ignored that second statement, but run that YouTube
All right,
video
Mr.
back.
Melnick,
It's there.
please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
That's true too. They don't have evidence either way.
All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are. Okay, back to Mr. Zachary's testimony.
Well, the rest of the day is going to be boring after
I know
that.
we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Suddenly she needs a break. I mean, maybe she just needs to use the restroom or something because she didn't go earlier, but wow. Wow, 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 wow. Holy moly. Like, what is left of this case at this point? Because I imagine he's going to say exactly that on the stand if he does testify. I'm sure we're going to have renewed supplements from Doug Weinstein, Steele, Shart, because now you have Woody saying it on the record that the state told me. I cannot say that I killed Donovan Thomas. Holy moly. Holy moly. We're all witnesses. We heard it. Like, holy moly. He knew he was going to go up there and say it. Like, this is crazy. I think it's interesting that she wants a break. I do. And yeah, that's Hylton. So the chats are moving so fast, but it was Hylton that told him. Sharon, I'm not sure if Kayla could just come out and say that her client, and in that moment of time, she represented him for that one day, potentially said such a thing. So, wow. It depends on how I feel when I wake up. I think the judge might be in shock because I think she doubted some of the, some of the stuff she heard yesterday. And at the very least, whether Woody genuinely means that he killed Donovan Thomas or not, or actually plans to say that on the stand, it seems very believable. Do you think a reasonable person could believe that he said that with Ms. Hylton and Kayla Bumpus in that ex parte, that chambers, whether it was on the record or off the record? Do you think a reasonable person could now think, hey, maybe that thing that's been in these affidavits, that the defense has been filing these motions around, using this affidavit saying that they heard that Hylton said, I would prosecute you if you say that you killed Donovan Thomas. And Judge Whitaker and Krause, they're like, oh, there's nothing improper about it. Judge Whitaker's like, I don't know if that rises to a mistrial. I don't really see evidence of that in the transcript. How would a reasonable person not have to wonder if that was actually said and then not disclosed by the state to the defense? This solidifies to me the Brady issue. like just crazy, crazy, crazy. And that's true, BFM. There is still, I want to say BMF, but BFM. Whitaker isn't going to do anything, ain't going to do anything. This will all go to appeal. These kids will sit in jail and spend more on attorneys. The state gets the conviction. And that might be true, but man, that's a very inefficient system. Inefficient system. Brady, Brady, Brady. Ms. T says, I told y'all Kayla wasn't lying. Black Clark, we didn't see that in the transcript. B-R-A-D-Y. Tom Brady. Oh, Michelle Brown, real easy. So they wanted to inquire if Copeland still believes he has an attorney, if Melnick was still his attorney. Melnick says, yes, I'm still his attorney. Spoke to Copeland over the break. Copeland's ready to give some information to Whitaker. He says he doesn't exactly understand everything Whitaker just said about the meaning of perjury and false statements. And then for clarification, he asks, well, the state told me, Hylton told me, I can't say I killed Donovan Thomas. Or she'll say that that's perjury, she'll charge me and hold me for that. Like, that's where we are. And then also, is he going to plan to testify? His answer was, depends on how I feel when I wake up on Monday morning. Like, come on. Come on. Judge is phoning a friend. Yeah, let's do a poll. Holy moly. I don't know why I was surprised by that, because, you know, it's kind of like expect anything. But that still got me. Let's do a poll. And this poll is going to be whether you think she will grant one, not whether you want one, but if you think the judge has, the needle has tipped a little bit. There we go. Quick poll. Quick poll. You guys answer away. Rest of the day could be interesting. I mean, you kind of heard it between lunch. Did anybody notice between lunch and when Melnick got on the Zoom? We had like an hour or so of time there where they're dealing with these admissibility of the statements coming in from witness Zachary. To me, it seemed like the state kind of sat back and Love wasn't really jumping up trying to make the arguments like she was this morning. Like her mind was occupied by what's going to happen when Melnick inevitably gets on this Zoom call. And then Copeland's in the courtroom waiting to come up and talk to Judge Whitaker. So I don't know how focused Love will be for the rest of the day. I think she needs this break more than anybody. But thank you so much for all the super chats that are coming in. I know I'm behind. Marlena says, Kayla, come look at this. Earlier, FFS, I thought this was interesting. So FFS said, I don't know how they can legally force immunity on Copeland. This was earlier. I caught a case in Miami-Dade. I was unlawfully arrested and got my A beat by multiple cops. The case was dropped. Prosecution wanted a release of liability. So in other words, FFS say, release us from liability for what happened to you. And you refused to sign. So love that you refused to sign. There is a lot going on in Miami-Dade. We have Michael Van Zampt, a prosecutor, had to step down because he had a jailhouse witness he was relying on for a bunch of his cases, that in exchange for jailhouse testimony or witness testimony, if someone told me this, I heard it while I was in the common area, I heard him say that he did it, that type of testimony. This prosecutor was relying on this person to be a witness, bring hearsay statements in, and get these convictions. And in exchange, he was giving this inmate conjugal visits. Like, I don't know if he was like finding the women or what, but a lot of crazy stuff going on in Miami-Dade. That prosecutor had to step down. We have the Courtney Clenny case where the parents, the whole laptop case gets dropped because the prosecutors at Miami-Dade State Attorney's Office looked through the laptop, looked through privileged communications. And then after the fact, they tried to say, well, we think there might be an exception because the attorneys and the parents might be working together to commit a crime. And the judge is like, well, what crime? What proof of that? And like 2 months go by and finally the judge is like, enough. And then the charges get dismissed. The state agrees to drop the charges. So big ethics problems there. There is an attorney. He's been a public defender. He's worked appeals for capital, death penalty cases, people that were convicted and sentenced. And his name is Stephen Gosney. He was recently hired to work in the prosecutor's office in Miami-Dade. And I'm so interested in seeing if stuff exactly like what you're talking about is cleaned up. Like, oh, we messed up. Can you sign a waiver? Because that shouldn't be happening. So I appreciate you sharing your story with us. I'm pretty close to Miami-Dade. It's not right where my local news. I don't get every little bit of news from Miami-Dade, but I hear enough. And I can picture it based on what I've heard, and I am glad you refused to sign. So thank you for your support for this channel. Miss AB, so funny, you said this at 1:41 p.m., but it could still apply at any time. She is trying to remix the laws, talking about love, shaking my head. So I appreciate all your support all day, Miss AB. You always come with like right on point commentary. Marlena Mack, either way, it's up to the judge. So she should just say that she's not holding him that long. And I thought that argument went on for way too long. She let Love try to come up with a reason why you should be able to hold someone in civil contempt for, everybody that's part of an indictment, even if they have separate trials, and the trial you're subpoenaing them for is just one of them. And Steele gave a good argument, but it was kind of more broad reaching. And then Carrington Matthews came in with the assist with like the pointed case law. And Judge Whitaker was like, thank you. We can put this to rest. I've made my decision, Miss Love. Stop trying to argue with me. So that was awesome to watch. Garrett, and you don't need to super chat it, but you had said, sadly, Kayla failed Woody. Melnick will do him right. I want to ask the chat, would you guys have criticized Kayla if Kayla came out and said, right in front of Ms. Hylton, Kenneth Copeland, my client for that moment in time, who I was trying to represent and protect his interests, how would you guys feel if she went on YouTube or went on the stand and divulged that Kenneth Copeland stated off the record that he may have killed Donovan Thomas? Because on the flip side of this, we would have been like, wow, she just threw her client under the bus, even if it was only the client for one day. However, we still somehow got the information. It was still in those affidavits. And I think without that, we wouldn't be exactly where we are right now. We might not have a different judge. So what do you guys think about the big picture, rather than the pieces of how we got here? What do you think about the sum of the parts? So I appreciate your support and all the thought-provoking comments, Garrett. Some of your comments are really funny too. And then Mahadi had seen this earlier. So when Carrington Matthews had came in with the save, not the save, because Steele did a good job, but Carrington said it in a way that Whitaker wanted to hear. But that's the challenge of 6v1. So you have 6 defendants and all their counsel against the state. And if you notice, the state, it's Atkins, it's Love, and then there's been one guy sometimes at the table behind them today. So really it's just the party of 3 versus the attorneys on the other side. And we even had the stand-in counsel. It's not Jay Apt, it's not Doug Weinstein, but he's from their office. I just don't know his name. But he jumped in twice with, an opposition to one of the statements coming in for Zachary. And then also he jumped in with some logic about civil contempt, how to purge that, and how this logically, it doesn't make sense to say that you can hold someone in civil contempt indefinitely. So even that guy, he's part of the 6v1 today. And he's brand new. I haven't seen him here in at least since June. And then also Mahadi says, new attorney, revised order, which we didn't actually get a revision to the order, but we got clarity on how it can be used. And that clarity, I think, was a big L for the state, because it was Whitaker saying, you got these bullet points wrong. I don't think you properly explained perjury and false statements. You got this stuff wrong. So on the record, that was a big L, even though it wasn't revised at all. It was still an L for the state. And then the transparency is a win for Woody. And you sent this at 2:02 p.m. It's been a bigger win for Woody ever since. Absolutely. Miss AB, this trial has had a lot of people saying, well, you just want criminals to go free. But succinctly right here, Miss AB says he has rights that need to be respected. And that's the foundation. The rights should be respected. Otherwise, how do we have faith in the justice system?
Okay. All right, so I think we are on page 90, lines 11 through 14. Okay.
Tony. Steele's typing away like Kermit. New motions.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon, that's the detective.
Mhm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. In my notes, I have on 90, line 14,
Mhm.
Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just,
But yeah. All right. What is this?
Hello, internet.
State say?
Your Honor, it's a question,
No.
it's not an assertion.
No.
They're asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send a link to the, no, he hasn't. He said it's taken 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
then also I'll bring it to you.
Talk into your mic, please.
On line 21,
Yes.
Investigator Dennis, my notes say, where it says indiscernible,
Uh-huh.
says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
And let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes
Sounds like more delay.
if the defense has a transcript they'd like us to use and like us to
Mhm.
we welcome that as well, but right now.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't
New
see
motion
how
from
we
Steele.
could agree to a transcript without all of us just sitting in here and
Well,
going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times, I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
like I hear this voice who is talking. All right.
It's God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right,
just based
and
on everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they've provided thus far. And we
Okay,
think, quite frankly, it's better for the jury to make their own determination about what's being said.
okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as the
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject. I think that may be the subject or the reason for the squelch, but I'm not going to be able to hear it otherwise.
Steele
unless
has a
somebody
new
wants to
motion,
come
you
up with
guys.
a little speaker that I can have up here with me.
Unless you guys want to look at it, and then we can watch on 2 times to catch up on or like 1.5 speed. So put a 1 in the poll if you want motion right now, and 1.5 speed to catch up, or 2, keep watching and read the motion later.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that.
Because Love is
Okay.
struggling anyway. Let's
And
read the
as long as
motion.
we're
We'll
gonna do
fast
this,
forward
we
through
might
Love
as well listen
struggling.
to both of the ones.
So I've got the stream paused. We'll be able to catch up. But here, we'll get through this real quick, you guys. So this is Brian Steele's additional motion. Additional motion to disqualify lawyers Love and Hylton. Notice that it was filed at 2:57 p.m. That was less than 30 minutes ago. So we know what the beginning always says. But the Honorable Court denied Mr. Williams' original motion to disqualify lawyers Love and Hylton on August 1st, 2024, based upon Mr. Williams' assertion that he intends to call lawyers Love and Hylton as witnesses at trial. Mr. Williams respectfully requests this Honorable Court to consider the ethical violation, so this is the new reason, made by lawyers Love and Hylton in support of this motion to disqualify. And we're getting a reference to Ford Motor v. Young. The enormity of violations of candor with the court, candor with counsel, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hylton to continue as, and shout out to Thugger Daily, I'll link to his Twitter as soon as we're done reading this, as lawyers in this litigation. The below is just a touch of the constant misconduct by lawyers Love and Hylton in this case. 1. Recently, lawyer Love filed a motion with this Honorable Court that undersigned counsel had a, quote, duty to provide work product. Lawyer Love knows the same is untrue, and the cases that she cited in the said motion did not support the propositions of law that she asserted in the motion. So she's referring to the motion to compel defendants' compliance with reciprocal discovery obligations. This was the 4th time that lawyer Love raised the same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on the same exact issue. So here we have some citations to those hearings. Back April 8th, 2024 is one of them. And then we have July 30th, 2024. 2. In paragraph 11 of the state's ex parte motion for order to compel testimony necessary to the public interest. So this is talking about the immunity, I think. There is zero truth to the assertion. We haven't seen that copy, but they have. They saw it last week. Steele is saying there is zero truth to the assertion that any defense meeting occurred with Mr. Copeland to impact Mr. Copeland's decision to invoke the Fifth Amendment or any other matter. Stard tackled this in what we read on Friday, I think. No defense lawyer on this trial had any connection or involvement with Mr. Copeland on or around June 6, 2024. This is a knowing misstatement by Lawyer Love. Prior to opening statements, the former court ordered all parties to share with did it go to the right page? Let me make sure it went to the right page. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aid that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, 2023, so that objections could be made prior to presentation of the opening statement. And they cite back, we watched that recently, Nick Starr replayed the opening statements, and we saw him call for a mistrial, right, during opening. On Friday, November 24th, 2023, at 4:58 p.m., Lawyer Love shared her supposed demonstrative aid. During opening statements at trial, Lawyer Love showed a completely different demonstrative aid in violation of the prior court's order. So they cite to that on November 27th. There have been no consequences for Lawyer Love's intentional, unethical, and continued misconduct. 4. During the same opening statement, Lawyer Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undersigned counsel had represented another person charged in this case. And this is back to that PowerPoint from opening statements. Specifically in her PowerPoint, Lawyer Love showed the jury that undersigned counsel represent co-indictee Blaylock. 5. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of his arrest on September 11th, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove. And I see you guys say that the document's there, so I'm going to pull it up. We'll read the rest from... Wait, I don't see the document link, actually. So we'll go on to page 4 with the picture, but as soon as I see a document link, I'll share it, or I can pull the document. That counsel fabricated evidence as Mr. Bean never went to Grady Hospital on September 11th, 2013. And then he cites the YouTube lawyer. And remember, yesterday in court, Brian Steele mentioned he's provided a thumb drive with YouTube videos that he references. So yes, he's linking to the YouTube videos in these motions, but it seems like he's preserving downloaded files of the recordings. He's not just relying on YouTube to stay up forever. Lawyer Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally, knowingly false. And then 6, over Mr. Williams' objection, when the state was attempting to introduce a January 26, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the prior court that only Mr. Williams' voice could be heard on this video and audio, except for one other voice saying, yeah, in the background. I remember this. Undersigned counsel told the prior court that Lawyer Love was incorrect and that several persons' voices were audible in the social media posting. Lawyer Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, Lawyer Love was proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of Lawyer Love and the state of Georgia in this case. And then, yeah, we have the footnote here that Lawyer Love never introduced the evidence on her table. So you had it on your table, you say, but like, what's up? And then next page. Reason 7. On Thursday, June 6th, 2024, as well as Friday, June 7th, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. Again, this was another knowing, malicious, false allegation by Lawyer Love as she continues her unethical conduct. And then 8. On Monday, June 10th, Lawyer Hylton, Lawyer Love, and the now recused trial court attempted to hide Brady evidence from Mr. Williams and the other accused that was obtained during the unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that everything he says is a lie, that he committed all of the crimes in the indictment and the like. These statements are impeachment of Mr. Copeland and are squarely within the concept of Brady v. Maryland. Moreover, lawyers Hylton and Love, with the assistance of the now recused judge, told Mr. Copeland that he would not get in trouble if he lied under oath unless he told a bold-faced whopper of a lie, that he could not be prosecuted based upon some erroneous theory that the statute of limitations has run, and Mr. Copeland would have to remain in custody until all 28 co-indictees' cases resolve. This is all unethical conduct in order to intimidate and coerce Mr. Copeland to testify at trial. And then we have one short closing here that specifies, and we'll get back over to the hearing, that the above does not truly encapsulate the horror of working with lawyer Love and Hylton, not to be able to trust the prosecution to provide the simplest and most basic fundamental fairness, such as honesty to the tribunal and honesty to all in the courtroom, must mandate that both lawyers Love and Hylton be disqualified from the case. So Williams requests a hearing on this motion, and at the conclusion asks for the relief to be granted. There you go. So I'm going to get this link. We're going to get this back on, this hearing. We'll catch up. And we're not able to hear what they're listening to anyway. So
Is
there we
the
go.
video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard drive.
Okay, so that's what y'all been doing, is using a hard drive?
We've done both, and
Okay.
that's what happened.
All right. What are we gonna be doing right now?
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen. What is this? What is this transcript?
Yes, the shock and horror for anyone that watched the Karen Reed trial. I don't think we have much we can fast forward through this. We might catch up and it'll just be quiet. Let's see. Atkins with the fast forwarding looks like he's jerking around.
At which one are we? At which one are we targeting first?
The one on page 90.
Okay.
I'm just trying to get. So where we are, the line he's at right now is the line 25 on page 89.
Okay.
So I'll just.
Sure, that's fine. Yep.
Damn, Slug right there. To take care of him. So Slug ain't go on the bus? No. When I told you, he grew up even on that. He got J and grew up on that no more.
But you said Shannon. How Shannon get involved in everything? So when they hear him speak, it's almost like call Shannon. Because that's what they say because. Shannon too.
Now, Shannon always be quiet.
Right.
He did. Yeah.
When it comes down to it, he's not scared.
Who shot Shannon? Who shot Shannon? They say he smoked. I don't know. I walked up.
All right.
It's in jail. I read you jail.
I heard what I need. Okay. That's definitely a question. Shannon the shooter?
All right, so one
And
for
then
the
answer is
defense.
No, he's quiet.
Plus one for the defense.
So 17 is fine to be
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking, who is the they that they're talking about? And I was just gonna maybe listen a little bit in front of that. But then, yeah, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is, or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Percival have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers our, on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so okay.
So I just put the link to the PDF of the motion.
All right, that takes us to
in
92.
the chat if you want to look at it.
Line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay.
So
So it's not the entirety of 92. That's just to give me context. Is it when, is it 93 line 21 where the real objection starts? 92 line 15. Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Matthews.
Recuse Judge Glanville in shambles. What did Whitaker just allow to happen?
Thanks.
Peep the face tattoos also.
Okay.
so Investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified, and he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused, and he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get Investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint to me, for me, on page 92, is there anything? Well, I guess line 15, like.
Right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kaikendo, and he's actually wrong about that. Fatty is Kaikendo. And so he's just kind of setting the stage of the people he saw. And then,
Starting at where? 15?
15.
Okay, yeah.
and then he's talking about the gun that
Right.
DK had a gun and he recovered the gun
Right.
and how he pulled out his gun and Jeffrey's sister Max took offense to it and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day. And I just don't think it's appropriate for it to be played in an out of court
All right.
statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relaying and receiving input from Mr. Zachary, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there
Mhm.
that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Oh, page 93, line.
Line 15 through
Mhm.
17, for instance,
Uh-huh.
where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Char said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are.
And why it's not cumulative.
Well, let me.
Or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
And thank you so much, So For Real and True, for becoming a member.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, so we'll redact that by agreement.
And thanks to Olafemi for becoming a member as well. You guys can race each other with the Mario Kart emojis.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93, lines 3 through 6, 3 through 9.
Okay, so that you believe should be in.
Yes.
All right, and
And that's because as Investigator Dennis is talking about Copeland, Batty, and DK being like this, Mr. Zachary is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and,
That's
okay,
our position.
all right. Any response on the 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine
right,
with that.
so that is then in by agreement, essentially. All right,
As we go on further down,
and then
I have no objection to 19 through 23 coming out, where Investigator Dennis is talking about Cookie Dolls, not Cookie Dolls, but DK's gun having been taken.
right, okay. All right, and so up above then, where he's saying DK had a gun, I recovered a gun, yeah, I saw that. Is he literally mean, yeah, I saw
These
that on the scene?
captions.
Yes.
Okay, yeah, that seems like that could come in. All right,
And Sarah JB, this whole case is built on snitches, WTF. I think that's the nature of RICO in a way. Especially like the way this one's going. So thanks for your super chat.
So lines 24
mm-hmm,
and to 25, line 93, lead into
Mm-hmm.
page 94, lines 1 and 2.
Okay.
We would object to that coming out.
Yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6,
Actually,
3 through 7.
well,
Or-
yeah, 3 through 7, that's fine.
Okay.
Line 8 through 10. In, we would object to that coming out.
Okay.
We would object to line 11 through 18 coming out.
Mm-hmm.
We don't, actually, we would object to line 19 through 25 coming out as well. Specifically, where only that Detective Dennis said lines 19 through 22.
Right.
But then Mr. Zachary gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Sharp?
No, Your Honor.
Okay, all right. I'm going to permit that in.
And so
So is everybody clear on what's out and in, or do you want me to, good?
I'm clear.
All right.
So the next section, Your Honor, is kind of picks up right where we are. And I flagged this because it was unclear to me at the time whether Mr. Zachary was claiming that he was there. But I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't.
Okay.
What is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with them. With who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters. And Quindarius Zachary says, yeah. He wasn't present for the shooting.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who wasn't present, saying
Right.
Pee-wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay.
When they try
So
to play
I
this, it's
think
going to be so
essentially that
choppy.
one is, okay, this is the law enforcement theory at this time, but
So we're starting on 90.
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way for open reserve the right. If I've asked that the court allow, if we are able to establish that foundation, then I've asked that the court not exclude it.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it
Okay,
or some other.
okay. Okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also, say, so with respect to Mr. Zachary, he has, and the reason we have some TBDs by some of this is that he has not been the most cooperative person,
Uh-huh.
and
Here we go.
I would leave it.
Okay. All right, so we'll just see on that. I understand the objection. I understand that it can't actually quite be answered yet. There's a foundational issue. We'll just have to see. Okay. So then we've got, I guess, what? 6 through 14.
I don't have a problem with lines 6 through 8. But then again, he starts theorizing about who's a shooter and who's not. And he says Troop wasn't a no shooter. He was there though. I think he was following them too.
I don't have an objection to, is that 9 through 13?
Yep.
Yeah.
I don't have any.
Okay.
And then I have a problem with 14 through 22. 14 through 25, really.
And is that same basis, like, how does he know this?
Correct.
Okay. Is that also by necessity TBD based on your frustration with your witness? Okay.
And
Well-
that leads into 96 as well.
Well, I would say 24 and 25, 95 lines 24 and 25 to 96 is really 96 line 14 is all speculation about why Jimmy Winfrey pled guilty. I don't think that's TBD. I think
Okay,
that would be.
all right, so hang on, we've got, I'm sorry, maybe I'm just not up with y'all. So 95, 14 through 23 is TBD, is that right?
That's right, yes.
And then when we start on 24, line 24 and going on, okay.
And then I was muted, but thank you to Emmanuel McCrae. Shout out to social media. Without it, this trial would be very different. And 100%. I mean, just think about like Thugger Daily, just Thugger Daily's efforts covering and giving updates on this case. The difference that it's made to get people informed and interested.
So the objection is on page 96, what lines?
I don't have an objection to 96.
95 line 24 to 96 line 14.
I don't have an objection.
Okay, out by agreement.
And Angie, thanks so much for your super chat. That's so sweet of you. Remember, it's Drea's birthday coming up this week. We're going to be celebrating for Drea. So big thank you to the mods and especially happy birthday to Drea.
Are we now at number 29?
Yes.
Okay.
And also, again, to Angie, thank you, Kayla Bumpus, for having the integrity to speak out.
Uh-huh.
So, Your Honor, the context of this is there's a gentleman named Rico Rich.
Mm-hmm.
Is it Rico Rich? Rico Rich. And he ran or owned a studio on Metropolitan that allegedly was also used at times by Mr. Williams.
Mm-hmm.
And at some point, this studio was raided, and marijuana was located at the studio, and I think Rico Rich was charged with it. It was his studio, my understanding. July 15th, 2015 is when that raid occurred, and it has nothing to do with this case. And so they're just talking about Rico Rich being upset because his perception that the attention drawn by the gentleman in court led to the raid, and it's just about something that has nothing to do with this case.
All right.
And Judge, if I can just add to Mr. Shart's
All right.
position, the state, we've actually addressed this previously. The state agreed that this would not come in.
Okay. Well, I will find out what Ms. Love says about that, but I think that maybe Ms. Love hasn't had as much of a chance to study this in detail as she would have liked and as I would have liked. And so, Ms. Love, is that correct that y'all had already agreed that this part needed to come out?
And this part, I mean.
99, line 18 through kind of, I guess, what, maybe all of 100? 100, line 10.
Just 1 second.
And you guys, so thanks Jeffrey Jordan for the super chat. Where has Hylton been? She's on vacation at a very important and exciting week. So, and I believe she'll be gone a bit next week too. So even with Copeland starting on Monday, I'm not sure she'll be back. And thank you so much, Cheryl, for the super sticker. That's so sweet of you.
Okay.
Page 99, lines 18 through 23. And I don't have.
Okay.
Shout out to I Did These Crimes.
Yeah, go on to the next page through about line 10. It seems to be the same topic.
YouTube chats are also a great part of this trial, like undefeated. Like come on, we have recused Judge Glanville, we have I Did These Crimes. And thank you so much, Starletha, with the $4.99 super chat. I appreciate it.
We don't have.
Okay, the court is quiet.
Frankly, 14, I think, or 15. Right? I mean, isn't that all the same?
15.
Okay. All right. And so that would also encompass 99, line 24, which I think we accidentally left out of there. So, all right, by agreement, all the way through 100, line 15.
So
that would be 99, lines 18 through 24, all the way into 100, up to line 15.
Right. All right.
now, Your Honor, if I could go off the list for a second, I believe
Sure.
one of my co-counsel has a objection to page 100, line 20 to 101, line 5. It talks about Jeffrey's family, how he likes to be in the hood, and he likes people that are going to be right there with him, same people he grew up with. And then investigator Dennis says, right, that makes you guilty by association, and that's improper. And then they talk about Mr. Bennett's aunt being shot.
Okay.
Your Honor, the state has no objection to page 100, lines 24 through 25, but we would ask the court to listen. I think I have a different take on lines 20 through 23 than Mr. Sharp. I don't think he's talking about Mr. Williams' family so much.
He's saying though, I'm saying though, Thug is family. He likes to, yeah, okay. I can listen to it. Do you want me to listen to it right now?
Regardless, it says he's hanging out with the same people he grew up with and then investigator Dennis improperly.
Oh, yeah, no. She
Yes.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then, so 100 line 24 through 101 line 4 are out by agreement.
And then at 101.9, they start asking Mr. Zachary how he would feel if his mother got shot while she was asleep
Okay.
in the bed and all of those things. And I don't think that's appropriate either.
So Judge, based on the court's ruling regarding 1 through 4, up through 11 would be okay?
Yeah, all right, well, you agreed with it.
I
All right, so all the way through 101 line 11. Thank you.
I mean, it continues beyond 11.
Okay,
It continues.
yeah,
But Judge,
Yeah.
with respect to the ones after 11, Mr. Zachary is saying his expressions, I believe, are relevant. I don't think that is the same
all right.
as 1 through 11.
And when you say his expressions, then you mean like facial expressions when he's talking, or what do you mean?
What he expresses, they just
Oh.
shot up my cousin's house. I'm mad, and I don't disagree with respect to
She wants to disagree with all of it.
Yeah, I think it goes to.
line 20. I don't mind all of that up to.
Okay, so now we're to 101 line 20 out by agreement.
Judge,
Yes.
if I may, the conversation continues on. It's this well beyond 101. I don't think reference to that incident ends until we get to page 102.
So maybe through line 8
I was thinking 18.
or 19.
Yes.
Okay. Yeah, I mean, yeah, essentially they're saying bad things happen. How would that make you feel? And he's not saying anything other than maybe how he would feel, but that's, you can feel whatever way. Aren't these kind of hypotheticals? All right, so through 102 line 19 out.
Mason Martin
I
says,
agree.
got our Rico now. I mean, it's definitely interesting that it seems like there's more conspiring to make this case a case.
Now, the next section.
So thank you, Mason.
So the next objection, okay, so that's carried us through 30 and 31 then, okay, right?
Yes.
All right, so we're now on item number 32, which starts on page 104, line 3, and goes to the next page, line 3.
And this is involving the Donovan Thomas case. And
Yeah.
I will say that in the other statement, Mr. Zachary asserts that Mr. Stillwell and Mr. Kendrick made some sort of statements against their interest
Okay.
as to who was in the car. But he never asserts that they told him about these details. And he's never claimed that he was there on Cleveland Avenue when he talks, here he's talking about a gentleman named Kelvin Treadwell, also known as OG Bentley, basically taking the guns and taking the car and disposing of those things. He never claims to have been there, and I don't think anyone's claimed he was there. He claims he was at a kid's party, and I think the state has accepted that. And he's never said that he got that information from Mr. Stillwell or Mr. Kendricks, and I don't know where he's claiming he got this information from, but until that is established, I don't believe that it's admissible, even as a prior inconsistent statement, hypothetically.
So, Judge, what Mr. Zachary said in his prior statement is that he got that information from two of the defendants on trial now. Following the shooting, at one point the night of at Mr. Williams' condo, and I believe the next one on the way to Miami. My memory may be a little bit fuzzy on that, but because he corrects one of the detectives when they're saying, so both of them told you at the condo. And he says, no, one told me at the condo, the other told me on the way to Miami.
Okay.
So our argument is that his recitation of what happened would have come from, he wasn't there, we've never said he was, would have come from the same place that he was made privy to the statements that we caught nuts down at, which was at the condo, on their way to Miami, because they were together. And by they, I mean various members of YSL. They didn't all go in one car together down there, but they traveled to Miami in the days after the murder. So
Okay, but this is about Bentley's potential involvement in getting rid of the guns, is that right?
So OG Bentley is alleged to have, yes,
Okay.
gotten rid of the guns after the murder.
Okay.
And our argument would be that Mr. Zachary would not have, he's not the only one that says that. They wouldn't, this collective knowledge wouldn't exist, but for his involvement in the gang itself. So this is another spot where I would say, where I would object to it coming out. But of course, I'm going to follow whatever ruling the court makes.
All right.
And I just want to be clear. I actually agree with Ms. Love's recitation of facts to the extent that he said that he got certain information from those individuals, but it's not this information.
Yeah, I mean, it does seem like, I mean, he could legitimately have gotten the information about two other people saying they're involved, and that's one thing, and that's not what this is about. This is about what was OG Bentley's involvement And did he, get and hide guns? And literally, even on 104, like towards the bottom, and they're asking about, they gave him the guns. He's like, that's what I hear. He doesn't even seem to be saying, hey, I know this from one of my in-gang sources. He's just like, oh, I don't know.
In the 2015 interview,
Uh-huh.
a little bit more detailed and a little bit more explicit. He
Okay.
references it. So at the very least, I think it.
All right, so how about if you can point me specifically to where in the 2015 thing it shows that he actually has the legit knowledge of this, then I'll reconsider it.
Okay.
Okay? All right.
So I'm just gonna put, okay, contingent on.
Yes.
Thank you, Rooster, for the support. Love the content. Keep up the great work. And Annie at 2:29, so about an hour and a half ago. Mistrial, please.
Basically, 104 line, what, 3 through 105 line 3? Is that right?
Yes,
Okay.
104.3 to 105.3.
All right. So moving on to item number 33, which is a little portion of page 105.
So the state has no objection to 11 through 14 coming out.
All right. All right. So that takes us to page 107. Our first
I'm gonna withdraw that one.
34.
Yes.
Okay. And how about 35? We're still gonna sort out?
35?
Yes. Item number 35, which is 107 line 23 through 108 line 1.
I didn't remember talking about that one.
Well, it's in your list.
No, you said we're still gonna.
No, I'm asking you.
Oh, yes.
So that's what we're moving to next, right?
Yes.
Okay. Sorry.
I thought
Like,
you were
wait a
saying
minute.
we had already discussed it. I got it.
No. Okay. All right, 107 line 23.
I do kind of understand why Glanville hated doing
Just
this.
a random discussion about a fight in a club that Mr. Kendricks allegedly got into with a man named Lil Tony.
Okay, does that have anything to do with this case?
What did he have?
It's a valid
No, it
question.
Thank you, Mr. Shard. I'm asking the state now.
So actually, Judge, going back to 106.
Okay.
So 106 just gives sort of context of the time frame, but from 1 to page 107, line 1, when Dennis is asking,
Right, is this about the time the beef's kicking off? Okay, well, they don't have an objection to that.
So it's going back to the gambling house shooting, and they thought the quote unquote the mob did it, but then we find out that apparently Kelvin Watts pillow talk with a young lady led to it being revealed that Kelvin Watts did it. And essentially they're asking, why did you think the mob did it? Why did you
Right.
mistakenly think the mob did it? Assume. And they're saying, oh, because Mr. Kendrick beat up one of them
Right.
named Lil Tony.
Okay.
And so I don't know why.
Okay.
And this is all around as Detective Dennis said, this goes back around, this is all around the time that this.
Right. So as I understand, the objection, it is to, well, it may be a little further up than
Right.
Line 23, right?
It really starts on 14. Why
Yeah.
did you think the mob
Yeah,
was
all right. So starting at 107, line 14 through 108, line 1.
So when Detective Dennis asks Mr. Zachary, why did you think the shooting was taking place? And Mr. Zachary is telling Detective Dennis, yes, he might be speculating about why they did a rival party did what they did, but he's also stating that Diamante Kendrick had just beat up one of them.
But this isn't, I'm sorry, it just for my clarification, this isn't one of the IF people, this is some other group, right?
where it says why y'all thought tomorrow and then I guess
Phonetic or
phonetic,
something.
right there on line 14.
Right.
If you listen to it, it says why y'all thought the mob was shooting, not tomorrow.
The mob?
The mob.
Okay.
And that's the gang that they assumed.
Okay. All right, so why do we need this? What is your position as to why this would be admissible? Line, 14 through the next page, line 1, hey, man, I mean, we thought for a while it was this other group because of this other beef that had gone down.
So as it relates to 14 through 17, we would stipulate to that. But line 18, where Detective Dennis says, y'all had beef all over the place. Y'all being his acknowledgement as he was telling Mr. Zachary of them as a group.
Okay. And Zachary at 21 says, yeah.
Yes.
Okay, so then 18 through 21 seems like that legitimately could come in. And then that brings us then to 22 through the next page, line 1, about, okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in. Because it seems like 20, you're okay with that?
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line on the next page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Short? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we'll move into line 23.
Yes.
I have no objection to 23. I have no objection to 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no, we won't.
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know. The last time we talked, they were talking about
Right, somebody else.
Nut and Greedy and
Okay.
Kel being half brothers. And
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay.
you know, if the state needs to play 14 through 19, I just say play the whole thing and you know,
Okay.
give context.
All right.
The agreed stipulations are
So
nice,
then
but
that
still.
actually starts with 109, line 23, or no?
Yes.
Okay. All right. So basically, they're withdrawing their objection to that.
Feels looking at case law over there. Thank you, Warren King, for becoming a member. And then Don Allen. No matter what the judge's intentions are, I couldn't find any of this funny if I were
111,
remanded.
7 through 9.
Especially since all this energy could be used on the motions that could free me. Cute picture, by the way.
Okay. What does the state say as to that?
That Mr. Zachary's response, no, thug just stopped messing with booty.
Uh-huh.
And the subsequent lines are important evidence in this case. Obviously, Woody is Mr. Copeland. He's the one on the stand right now.
Uh-huh.
I can't.
Yeah. No, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question.
It's not a question, though.
Between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well,
of
it says,
I mean,
word I got is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and
yeah.
even if they had, that needs to be come from the stand.
He starts out with how did Shannon.
Yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Thug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody in?
That works. Thank you. Thank you.
Thank you.
And thank you, Kushi. Yeah, longest trial in Georgia history.
113 line 20 through 114 line 3.
Right when we're ticking away about a decision on
Before
mistrial.
we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But there are, how many, two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, I mean, some of this I am having to make rulings on, but a lot of it, it's like, it might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time, by which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now. So can we sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on?
I have no problem with that. I know
Thank you.
Mr. Sharp was endeavoring to give us another.
He's got, this list is great because I just need, okay, I need the responses to winnowed.
You said defense was prepared. I like theirs.
Okay, he gave us to us from one of the other interviews. We need the last one. It's pretty.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these two, he can be finishing the third one, if he doesn't have it yet.
I'm trying to remember. I'll talk to the state afterwards. I want to make sure I'm on the same page with them about the 3 different statements.
Okay. So I'm sort of thinking I don't want to do any more of this. How about that? Because
thank God
y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
Your Honor, we owe the court exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I'm kidding. I understand this is a monumental task, which again, should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're gonna be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems reasonable. All right, what else?
And also, the court asked us at the beginning of the week to have the next.
Yes, the next tranche. Yes.
Yes. So
Where are we on that?
we count, even that tomorrow night is the end of the beginning of the week, but I don't know. So we're still
You're, okay, all right, I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely, yeah. I mean, but we got to have something to at least start with. Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with Mr. Copeland, which may not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning. But I'm gonna have, that'll be, it's gonna be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as well, since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agreed to it.
Your Honor,
Yes.
I thought the people charged here position was, and I think the state's position
The
was
12th.
just to include the 7th, which really was not anything, and then
10th,
the
11th, 12th.
10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity fully and correctly informed to make a decision about whether to testify, then if he says, no, I don't want to, throw me in jail, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, an odd scenario.
If we don't get to cross-examine Mr. Copeland, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that, of course, comes with risks. So it just, a lot of this is up in the air depending upon. I think if he says, now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with. So
I want another motion from Harvey.
So y'all be thinking about that.
Did Your Honor get the thumbs up?
Yes. magically. All right, anything else before we break for the day early? Because I'm going to go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of,
Okay.
where an expert, he's already been qualified. His name is Agent Bernie, B-E-R-N-I, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice.
For Woody.
And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Miss Love.
Yes. So the new phone number there was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with some of the alleged parties to the crime.
Okay.
Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder.
Okay.
So why'd you disclose it late?
We got it before now, but we got it after the trial began, like between, I think, January and now. And I think it was inadvertent that it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The report from the investigator, from Detective Bernie, involved plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two because the green store is a thing that came up recently during trial, and the other location was
when?
So we have two understandings of what the court is asking. So we're not talking about the plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
We're talking, I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
Hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
B-O-Y-E-R.
Boyer, okay.
On Monday, yesterday.
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well.
Okay. Nobody really I'm sorry, do y'all care, is the objection to the charting or,
It leads me to believe that they've had them for a while if they've plotted them.
all right, so the
they
the
panicked
plotting
yesterday.
of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay, and y'all just recently asked for that based on some testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay, all right, so then let's back up to the original issue. When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know the answer.
Can you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently, like 2 days ago, was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that based on the phone records, this person was in the car.
Okay, so when did they ask for, we or they, not we, but y'all or they ask for the phone records because they thought that might be?
I beg the court to allow me.
All right, find that out. And then, do you know when y'all got the cell phone records?
When you said we, I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay,
But
so
you're responsible for them.
Unfortunately for you, we equals, y'all
Thank you,
equals, the
Judge.
state equals both the DA's office and the Atlanta Police Department. You know that, and I know sometimes there's a little lag in communication, but I need to know, was it, if they were provided to the defense on Monday, was it last week or was it 4 months ago?
Okay, I can find
No, because, okay. And what do these cell phone records reveal? That this person did appear to be also in the car? And
There's two cars.
okay, do you know which car? I mean, there are two cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved?
The state
Okay,
is alleging that there's a white car with my client and Mr. Garlington in it,
Right.
and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars, and I'm inquiring what,
mm-hmm.
I don't know anything.
I'd like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
Because it was not a part of the original. Yes.
Okay, how long has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, except for this, I could tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a
Feels
jail
prepared.
call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing. I still, to this day, have no reports on it. I've
Okay.
never interviewed him, I didn't open on him. He could be
Right.
a great defense. I have no idea who this person is.
Yeah, I mean, yeah, this is, I mean, you know, potentially significant information for the defense to know about.
I can't say that at the time we did openings that the police had this. I'd like to be able to say.
All right. All right, we'll find out, but there's been a long period of time between opening and now. 8 months to be,
That was 24, okay.
7 or 8 months. So, yeah, we need a lot more information about this. I love how y'all save all of the like bombshells for late in the day, right before we're wrapping. Y'all like going, hey, guess what?
That's true.
So, okay. I mean, it is what it is. Okay. So we'll need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you also, I believe, we're going to get by tomorrow actual, like a list to the defense of here's what we think is a co-conspirator statement, right?
Wow, I still haven't done that.
We'll be waiting anxiously for all of those. Anything else? As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Ah, Miss Love misspoke. Did Miss?
I might have put a date wrong, but I'm talking about a 2015. I think it was August 2015. I believe March 2017 and the proper. So I'm sorry. I might have misspoken too.
Okay, so you think that maybe there only are 2, but you'll confirm that for us tomorrow? All right, and so if there are only 2, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to 2 full statements, right? Or proposed redactions.
I have. I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the court needs to finish the court, just allow me to get this thing copied.
That was a crazy last like 15, maybe 20 minutes. Like, they disclosed something new on Monday when they were panicking about Woody coming back and testifying. Like, that sounds like a Hail Mary move. And then thanks, D Camp, for becoming a member. I had seen you ask. Yes, this is a Geneseo Night shirt. Lola saying, Judge, please. I think kind of the whole chat.
All right, that's fine. That'll work. Thank you. All right, see y'all at 9 tomorrow. We'll be 8:45 at it when we have the jury.
Okay, 9 o'clock tomorrow. I think we'll have more motions. I'll clip the Brian Steele one that we looked at already about probably an hour and a half ago. But if new ones come in, either tonight or tomorrow morning. But Dee Dee says, this judge is making them work. He's putting them to work. Glanville would just let them do whatever, whenever.
All right, so we're adjourned.
Garrett says Love and Hylton equals the Brady Bunch. They'll just make like the panel of the family, but start putting all the state and their players together, put some of the detectives in there. And you know, I don't know. This will probably autoplay into something else, you guys, because I don't trust it. So we're gonna let it play, see if anything else comes up. If Love has a encore to bring us. Maybe the state, I mean, maybe the defense, they kind of had some last minute things too. And Lottie B says, I think the judge is looking for a reason for a mistrial that doesn't implicate Glanville. The potential new Brady could be it. And yesterday she was focused on that Brady, for sure. And I think that this ties in really nicely. So thank you so much, Lottie B. But Garrett had also said, and I'm catching up with some earlier chats, Garrett had said the defense is finally reading what Judge Whitaker wants. Attack the DAs, not Glanville. Especially because she's saying that the Glanville issue's been cured because he's gone. Bruce Harvey has the outstanding motion for, you know, we don't agree with the mid-trial substitution of a judge, but if anything else, as far as ending the case because of misconduct by the judge, judicial misconduct, Judge Whitaker's been like, not really having that. So shift your focus. Look at the prosecutors. And then we have all day Monday. We have Kayla Bumpus. We have Attorney Melnick. We have, honestly, I don't think Adam Abady. I don't think Peter Herzog. And of course, Detective Long. There we go. I think we're tuning out there. I don't think Detective Long helped. I don't think any of them helped the state at all. With the exception of Kayla and Melnick, the state called all those witnesses yesterday, and none of them helped the state. And it gave a whole bunch of new fodder for the defense to come and make this argument, and for Whitaker to think about this context that she thought she had, because she looked at the transcript, got all this new stuff. Focus on the prosecutors and what they did wrong, and how we might not even know if there's more stuff that they did wrong. Because what was it that Brian Steele's new motion that we looked at earlier said? The horror of working with Love and Hylton. The 8 points that he laid out in the filing that we looked at earlier. Brian Steele said, don't even touch the surface. So as a strategy, it is now the time for the defense counsels to try to disqualify the prosecutors, to ask for a mistrial because of the prosecutor's conduct. And they have so much more fodder. Thank you so much, E. Capone, also for the $4.99. Keep rocking. Here we are. And then Don Allen, great question. So did Ms. Weaver finalize the transcripts yet? So I don't see anything official filed for June 7th. However, we did hear Judge Whitaker say earlier in the day today, it was right in the beginning, you know, I'm pretty sure Ms. Weaver has gotten all of those relevant transcripts over to you, which to me, I take that to mean June 7th, like the court hearings, through June 12th, because that's the part of the transcripts that would be necessary for Brian Steele, for Max Shart, for the state to look at and decide, well, what do we want to argue to come in for Kenneth Copeland? What do we want to strike? Do we want to strike any of it? And we heard Whitaker at the end of the day say that's the gray area. She's acknowledging that that's a gray area for her, that she's trying to just come up with a resolution. And her voice, her confidence didn't seem like it was 100% that she thinks she's got a resolution. And now with Kenneth Copeland getting up on the stand today and saying, depending on how I feel on Monday morning, that'll be what determines whether I want to testify or not, or go be held in contempt. I don't even think she's confident that we're going to move forward with Kenneth Copeland as a witness for testimony. And so Brian Steele is now like, all right, well, if that's the situation, then I would be okay with striking everything. And if that happens, those videos wouldn't come in. The jury would be told to forget them, but I honestly think, what do you guys think? Do you think the jury remembers more of Woody's testimony or more of the videos that they started to play? So I do think Ms. Weaver did provide the transcripts to the both parties about anything relating to Kenneth Copeland. And then I had tried to read this. Lola Dane, thank you so much for the $9.99. The longer the judge takes in ruling mistrial or dismissal, it keeps prolonging the trial and the motions continue to mount. The case keeps getting messier. She's efficient, but she isn't cleaning this up. And she mentioned we've got these bombshells at the end of the day. Yesterday was kind of like a bit of bombshell sprinkled here and there throughout the day. And it's just adding more stuff. And likewise, we get a new filing today from Brian Steele for a mistrial. An additional motion for disqualification rather than a mistrial, but same thing. He wants a remedy. And he wants a hearing on it. So if they're going to make oral arguments, that's going to push the calendar back. It's going to take time. You know, Brian Steele didn't really speak much all day. So if he's allowed to make an oral argument about this tomorrow, it might be lengthy. It might be lengthy. And I do think she's efficient, but I don't think it's practical to clear up. I don't think it's practical at all. And you guys are kind of in the chat saying, you know, where, you know, maybe she's trying but can't. She's going to have a third one for tomorrow. The jury forgot everything already. And also shout out to, so Jay Capoti said his daughter, his little girl, listens when they're driving home. They listen to these law streams, these trial streams. So shout out to Aubriana. Shout out to Aubriana. Glad to have you listening. And then this one I've been wanting to get to when I knew there was a moment of silence. So Kushi says, Woody killed Nut. He was in the car, has the gun he used to shoot back, never brought it in. They never did a ballistics report. He's willing to sit and he can confess with the immunity regardless if they believe him. And that's the thing, like, so thank you for the super chat, but I don't think the state really cares about prosecuting him or not. It's just insane to me that he could possibly be the one that did it, whether he actually is or not. They didn't do the ballistics test. We're missing other reports. It's possible it seems like they want to admit cell data that might not be reliable to try to make the case that Kenneth Copeland wasn't in the vehicle based on one phone number that was not in either of those cars around the scene at the time of the crime. And Brian Steele is fighting to keep that out. I think all of the attorneys are adopting that motion. They're all like, of course, why would they want late disclosure, late evidence to come in, especially when the state has been screaming about reciprocal discovery from the defense that they're not entitled to. And they had the time to do that. They had the time to do that on Monday, right? So Kushi's pointing this out. The state had the time to run and do this, what I'm calling a Hail Mary move, on Monday night, about this person that Brian Steele has already checked his database for and only sees one mention of because of one of the jail calls. But the state hasn't figured out their version of instructions that they might want to give to the jury. They haven't figured out their exhibits. They still haven't named their next 30 witnesses. They still haven't provided a list of co-conspirator statements. All of these things that the judge has asked them to do how many times? But they're coming up with a Hail Mary to get in front of the jury coming up with the same conclusion, whether it's factually true or not, whether it actually is what happened or not. If the jury is connecting the dots the way Kushi is right here, it's over for the state. And they came with a Hail Mary. So I've been wanting to get to this comment. Thank you so much, Kushi. Or maybe it's Cushy. So I'm sorry if I'm saying it wrong. But just think about that. And this whole trial could surround a situation where it was somebody else that did the main thing. And then Joelle had said, I feel like the prosecutors forget this is America, the land of the free, presumed innocence, the Bill of Rights. Prosecutors in America are out of control. And guys, I really don't think this judge is playing lightly about Brady. You know, if we listen to what she's questioning, if we listen to what she's saying, and she seems more comfortable chastising the state. And she's not chastising the state in a way that's both sides need to be more professional and do better. Neither side should be doing this. She's saying, you, the state, you, the state and the police, because you guys are all part of the state. The DA and the police are we the people. The state is the prosecution and the police. She's not saying y'all as in you and the defense. It's not both sides of y'all. It's you, the state. So luckily, I can't say that I think the judge has forgotten this. I want to see more action personally. That's my own bias and lean at this point based on what I've seen. But the prosecutors certainly seem like they've forgotten this is America. So thank you so much for the 20, Joel. And then Big Tit says the judge is on record stating advice given by the state to convince him to testify was not, in fact, in meeting, prompted by ineffective counsel. What the heck, yet no mistrial. Technically, she's still looking at, there's still some outstanding motions, but she mentioned explicitly today she is still looking at shards on certain key issues that Love has failed to respond to. And now gets a lucky break and gets till Friday to respond to it. But do you think she'll file that on time? Well, thank you for your super chat, Big Tit. And then Annie says, mistrial ruling, please. This seems redundant. It's going to go in circles. And what if Copeland gets on the stand and does the same thing? And what if Zachary, the next witness they plan to call, the state said that they don't think he's that reliable either. She kind of mumbled it. Love mumbled it a little bit, but she did say it. I heard it. She's saying that Zachary is not reliable either. So what if Zachary wants to do the same thing? And guess what? Judge Glanville's not here to allow them to call an ex parte meeting that they're not going to disclose to the defense to figure out some way to make him testify. So if you think it's redundant now, I think it might continue to be. Thank you for the $1.99, Rob O'Neill. Garrett says, can Woody come up in a three-piece with a Tom Brady jersey? Just Brady, Brady, Brady. I think it's hilarious when people use little signals like that. Shout out to Mark Weeks for becoming a member. Marlena, I had pulled this up while it was happening. This was from when Woody was on the stand, but Love is shaking like she's standing before the Lord. Tina, thanks so much. Tina says, I absolutely love this. She so clearly earlier was wanting to push this off until she had time for Judge Glanville to tell her what to do, and now she can't do it. That's really been enjoyable to see the demeanor shift from the state. And honestly, again, from the defense, really to see Max Sharp be able to get his words out without being yelled at like he's a dog that misbehaved. Looney Boy says, Lil Woody knows that 1, he killed Nut, and 2, the state has nothing proving he did not kill Nut, because we wouldn't be here in 2024 prosecuting a rap group. He can say I did it, and the state's case is cooked. And I really think if the jury doesn't like Love, has a bad vibe about Love, maybe even Miss Hylton, the jury can make the determination that they don't find the argument of the case to be credible. They don't agree with the theory that Love is putting forward. They could find that Woody's more credible than Love, that they believe what he's saying more than Love. And if the chat is any, the chat I think considers all possibilities, but I think a lot of people in the chat are curious if there's any evidence that proves these YSL co-defendants are the ones that actually killed Donovan Thomas. So definitely will be interesting to look out for if we get to a verdict, if we get to deliberations. Dante, thank you so much. Kat, Kayla failed Woody by getting on YouTube and talking about the case. She has jeopardized the case. I believe it's an ethics issue. So it might be an ethics issue, but she's not representing him anymore, and I'm not sure if anyone would take an issue with it. So to me, I just see it as being moot. And I ultimately really think the state saw yesterday as a shot to, lean on Kayla and her testimony on the stand to say that we didn't do anything wrong because Kayla went and told everybody. And I just don't think that the judge agrees with that. So the elephant in the room in this case, when push comes to shove, the elephant in the room is still the state did something. They had conversations that they should have disclosed as Brady, and they didn't disclose it because they felt like they didn't have to. And then, oh my gosh, yesterday we get late disclosure of evidence that they probably should have disclosed earlier as soon as they knew that there were new cell phone records relating to a phone number that the defense wasn't aware of already. Even just identifying the person to the defense. Oh, yesterday, right after things hit the fan yesterday, they're finally disclosing something new. I still think the elephant in the room, no matter what, is the disclosure issues. Whether, Kayla said something on YouTube that maybe we think we got the wrong impression. Some people did get the impression that someone was going to get up there and say, there's a whole block of text that should have been transcribed that wasn't transcribed. And I just think that's it's kind of like a side story. And the conflict of the side story is still the state doing something, having conversations with Woody. So I appreciate where you're coming from. I think it's always good to make sure we're watching our own backs, trying to do the right thing. 100%. But I just don't think it's at the end of the day, I think Detective Long got on the stand and validated exactly what Kayla was saying. That there were conversations, and maybe Kayla didn't know when something was on the record or off, because Detective Long didn't know either. And then she loves fantasy. So she calls it bombshells. Attorneys say things she doesn't know could fill the gulf. Yeah, too much for her to comprehend. Well, and I think the other problem is this is another issue of mid-trial substitution of a judge. It's going to sound like some of it is kind of bombshell in new, or a new take, a new layer on top of something. But other stuff is stuff that has been known, but just isn't known to this judge because she came in on day 100. Day 101, technically. So you're exactly right, She Loves Fantasy. Good to see you. And so no weapon formed against me. Did Steele file the motion to disqualify Love and Hylton today? That came in at 2:57 p.m. I can drop that link again. You can see the timestamp right on the top. So on one of those bathroom breaks, I think he might have gone out there and put that through. And then Garrett says, in ex parte, Hylton had said, "We know you didn't kill Nutt. How? Why? What evidence did she have to know this? And did she give that evidence to defense Brady?" So I do really think that they're going to lean on cell phone records. And it sounds like they're talking about 2 different cell phone records. But it sounds like they're going to lean on something that says that Woody might not have been there when this all went down. Which, I don't know if that's a strong argument. I don't know if they have an expert that will qualify to come in. We've seen the state try to bring experts in, and even Judge Glanville said, no, I'm not going to qualify you. So that's all to be determined. So I think they're going to try to put together something that might suggest something. But bottom line is, if Woody does agree to testify and he says he was there and he decides to say that he did it, how can that be countered? Because even if the state puts forth cell phone information, the jury still gets to decide what they think is more compelling and more credible. And if they disclose it to the defense, probably not. Probably not. And we'll see if Whitaker takes issue with that. And then Olufemi says, at timestamp 2:30:14 on Friday. So hold on, is it from like a law and crime feed on Friday where Simone calls Glanville uncle? And do you mean Friday that just passed? So I'm going to keep this bookmarked. I'll look in the regular chat. Miss AB, thank you so much. I think it took her a while to get her footing walking in this far down. She clearly sees the issues and is giving the trial a chance before she shuts it down. I think she's seeing more than she expected to see, for sure. And I always appreciate your insights. And then Billiano Fever for $10 says, good night, Cat and Chat. Yeah, it's been a long day. You sleep well. Have a great night, everybody. See you all at work tomorrow. Today is a Remy night for me. Listening to the new Yay or something. Oh, so you make music. That's what's up. You might want to check out Classy Beats. He does, I know they're mic giveaways, but he does like a show where you can present your music. And Classy Beats, he comes into this channel. He's been up as a panelist, if not yesterday, maybe Friday. So you might know who I'm talking about if you're not already subscribed. But you should bring your music up over there and we can all go over there and listen. So hold on, let me find Classy Beats. And get your music up on there. So there's that. Okay. And then your family hates it. They say you're washed. Well, don't listen. Let me see. I want to see. Okay, so last Friday. And was that Law and Crime? I think you said yes. So we're going to try the Law and Crime stream at 2:40. Okay, so tomorrow night. Thank you so much, Mixed Chick. So tomorrow night, we'll have music reviews. Classy Beach channel. So we got to get you up there. We got to get you up there. Okay, and then 2:40. I wonder if I can just search the transcript for Uncle. So 2:40. Oh, 2:30, 14.
Okay, and then with there being a prior bad act.
To that alleyway.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one. The next one. We agree with based on, of course, prior ruling, Center Deck, page 231, line 5 through 233, line 22.
Oh, do I have the wrong?
I think it should start at 2:30, line 20.
I think I might have the wrong timestamp or the wrong video feed. That's hilarious, though. Okay, so Simone was wearing pink. Let's try day 103. And thank you for becoming a member, Sentinel. And then, okay, so Stephen Hickman says fans said the cell phone data proves nothing. Yeah, and I've seen conversation about it saying that. And I haven't really seen Brian Steele talk about it in a motion unless it was an old one. If it's in an old motion, we can pull it up and look at it. But it's kind of like I've seen cell phone records come in other cases, and the theory is the phone. We don't know who is using the phone. You don't know if it actually means anything until you see what the expert says and what the state's theory about it is. And I'm in a position where I don't trust that the state's evidence shows what they tell us it's going to show. So I wouldn't be surprised if the fans are right and that the cell phone data shows nothing of interest. And then D-Love for good music. See, look at all the music people in the chat. So, hey Kat, love your content. Do you think Woody might seriously consider pleading the fifth since he may only have to stay in jail for months, assuming the trial ends in March 2025? I think he's considering it. I mean, that's the question he keeps answering or asking. I really think he'll be ready, especially he was in a white tee today, looks like a little bit more comfortable. I don't know. I guess we can finish while we look for this pink blazer. We'll check day 103 before we get out of here. Yeah, did she call him uncle on the day Kayla was in court for the Rule 22? So we'll look at that. But while we close up, we're finishing up everything else. Do you guys think on Monday, how do you think Woody is going to feel on Monday morning? Think he's going to feel like testifying or not feel like testifying? Thank you so much, D-Love. And then what was our timestamp? We got to go back to 2:30. And
I wanted to bring to your attention that language that I just gave you out of Johnson is I thought right on point and bad for my position, but, you know, we just tell the truth. So I don't want to argue with it, but then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, you know, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have.
So I think we just have the wrong timestamp. You know, maybe there's a tweet. Or maybe we can do that. Maybe we can get a short clip of it and just upload a YouTube short. Which apparently Doug Weinstein keeps referring to TikTok or YouTube shorts as TikToks. So we'll just call it a TikTok. Maybe we can get a TikTok of the clip. And yeah, I think you guys are right. Woody might not want to go to jail for somebody. He might opt to go to jail for somebody. Jail for 1,000. He'll continue with the I don't recall. He's going to plead the fifth. Poll us. You guys want to do a quick poll? We can do one quick poll. It'll be a 60-second poll, so it'll be like flash round. Okay, poll. Woody will. There we go. You've only got 2 answers. There's no maybe. You got to pick the extreme. I've got my clock says, I didn't know when it started, but I'm going to watch my StreamYard clock for 60 seconds. And this is a great reminder. So Stephen, thank you so much for the super chat. In the Trump trial, they were using cell phone data, Celebrate data, about Wade's phone. And in the rebuttal, the state, Fonnie Willis, said the cell phone data is not reliable. And look what we're trying to use to keep this case together, this YSL RICO case. We're going to look at the same thing we said wasn't reliable in another high-profile RICO case. It's like too much. like, come on. It seems like a joke. It seems like a TV plot. Got a couple more seconds on this poll, guys. Get your answers in. 75% say he's going to not feel like testifying. That's a pretty big difference. 1 versus 3, like 1 saying he'll testify, 3 saying he won't. And I do want to say I also got a Cash App from JC with a TikTok link, and unless I have the numbers wrong or I'm typing it wrong, let me end this poll. But he sent a TikTok for us to play. I'm going to end the poll. With a clean, it looks like 25. Did we get a clean 25 and 75? 75 and 24. So it must be a roundup issue. So who knows? We're missing votes. But yeah, I got a Cash App with a TikTok to watch. But I tried typing it in. Let me try one more time. CTNBNEQ9C. No, it keeps like redirecting me every time I do it to like this video is about a house vanishing. So JC, I'm sorry, I'm not getting. If you're still listening, JC, I'm refunding it, not to offend you, but because I couldn't play it. So, man, I had it right. And maybe it's because I'm trying to pull it up in a browser. So JC, if you're still watching, I'm sorry I can't find the TikTok. It's not loading for me. But yeah, that's all I've got. I think we're caught up, you guys. I don't see any new motions at this moment in time. Again, one last time, this was the Brian Steele motion. the additional motion to disqualify. And there you go. Sapphire Ridge News thinks he's going to get up there and say, I told Hylton on the 10th that I unalived Nut. And he was ready to say that today, so he might get ready to be right up on the stand, say the same thing. And I think we'll immediately hear motion for a mistrial. Move to mistry. Which means 2 months just to get the same witness back on the stand for the same possible outcome. And I think at that point, how do you say the case should still move forward? So tomorrow, guys, we'll be back tomorrow. Hopefully it's a bit more entertaining than these evidentiary issues. Remember, no court on Friday. And Monday looks like the big day for Woody. So we've got 2 more days to hash out any nooks and crannies, but she wants the jury back on Monday. So, all right. Okay, wait. We have this open still. So 231:26 right after Steele. And that can be our closing note.
Yeah,
Uncle
that
Glanville.
does not mean is not a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all 3 of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes.
All right.
Okay, so Hylton's about
Thank
to speak.
you,
We'll see if
Ms.
this is it.
Hylton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the states. Discussed with Judge Glanville at the redactions that we had previously discussed with Judge Glanville for the states.
Oh boy, that's hilarious. It's one of those things that happens, right? It happens. That's really awkward when you're looking to Judge Glanville to help you out so much and then you accidentally call him uncle. Oh my God, thank you so much for the detective work on that timestamp, Olufemi. Holy moly. I feel like I remember that happening when I was watching this, but it's funnier to go back and watch it on loop. You know, watching the stream and letting it play straight, you don't really get to react or digest it. Oh my gosh, poor Miss Hylton. Ashley Linnell, thank you so much for flying in with the super chat here. Kat, remember Kayla said, Woody said, I know something about the infinity no one knows. All of a sudden, they give new information to the defense on Monday, yesterday. I think Love is lying and they've had it. That's a great point about that infinity. We'll see what cars were involved. And maybe that one jail phone call with, what was the guy's name? Boyer? Yeah, Boyer. Maybe that one phone call with Boyer will be relevant. And maybe it'll be more relevant for the defense to counter this evidence. That's a great point. Woody had something to say off the record during the June 10th meeting about an infinity. Kayla Bumpus got us to hear about that on the stand. Detective Long tried to say no, but then conceded that, yeah, there was something about an infinity talked about. And maybe this new Hail Mary that we got yesterday relates to that. That's crazy. That would be so dirty and it wouldn't surprise me. You guys are in the chat like the Uncle Judge Glanville. Oh my goodness. And just so you know, this is 232:37. So I don't know if it played out. I'm going to put my own comment on the screen just to memorialize it. And then, okay, link in the chat for that TikTok clip. Hold on, if you still have it pasteable, can you paste it one more time? And Miss AB says, I need Woody to live his life and be a productive member of society. Being in jail for a lot of his adult life has limited his opportunities. He needs to be and stay free, definitely rooting for his success. And I don't think that these co-defendants should be the ones on trial if they're not the ones that did something. I think the criminal justice system should be about getting people to become productive members of society. And honestly, if you're innocent of something, you shouldn't be in this situation. And if you did something, but you change, you become a productive member of society, then we've got to reconsider whether we want to keep you incarcerated. And I get that there's a balancing act with that, right? But I agree, the aim of this justice system, the criminal justice system, especially in America, should not be just to punish people. It should be to serve justice and create a better society. NJ. Okay, 1 minute mark. Hold on, wait. Let me open on YouTube so I can paste the link. JC, can you paste the link again? If you still have it on your clipboard, your copy and paste. Yeah, I've never slipped and called someone uncle either. I think I told you on this day, this must have been Thursday. I called my 5th grade teacher, who's a guy, mom. So that was my story of calling someone the wrong thing. Oh, you know what, JC? If you're posting a link in YouTube, it might not be letting your comment go. Is this just the clip where, you know, the one that Doug Weinstein wanted to bring in yesterday, where Kayla ends up saying, was the transcript complete? And Woody was like, no, you know it ain't, or something to that effect. Don't take me verbatim for that. But if that's the clip you're referring to, I know what you're talking about. And that was, as someone in the chat had asked it, and it was Woody that said, no, it's not complete. So there's a different clip. So I don't know, but it's not going to let, I don't think it'll let you put a comment with a link in the YouTube chat. And when I typed it, I promise I typed it twice. From your Cash App, it didn't work. So I'm sorry. And then, yeah, so I think we're caught up. By the way, the TikTok video, it redirected me back to the homepage, and it's just had this looping. Some guy cleaning up it's kind of pleasing to watch, but this is what TikTok gave me. But yeah, I think we're all caught up, you guys. So, and then Tina, I almost missed you. So Tina says, so yet another obvious Brady violation in the last minute. Another motion by defense on top of the one that Steele filed this afternoon. Has there been another motion in the last couple minutes? I wouldn't be surprised. I don't see anything new yet, but there might be some filings coming in tonight or tomorrow morning. So I know court's supposed to start at 9 a.m. tomorrow. I might start earlier if there's motions that we want to read first. But I think the only other motion was this additional motion to disqualify Love and Hylton. So, but again, Tina, I would not be surprised if something else comes in. So thank you for your super chat. Then yeah, let's wrap this up, you guys. You guys may have seen MG Law in the chat earlier. Very knowledgeable. You may have heard me say he has a podcast voice. He's going to go live to talk about motions and the happenings of different things going on in the YSL trial. I saw him. It came up on my feed. So I plan to hop in there tonight. He does late night streams. So this is like 5-6 hours from now. But this is MG Law. So if you want something to do in 5 hours, 5.5 hours from now, I'll be in the chat over there. I'm looking forward to seeing you guys. If not, see you guys tomorrow if you want to come hang out. You guys all have a good one. Thank you so much. Bye-bye.